Now you please come to the plain reliefs. Page number 30.
Obtaining occupancy DDT and directly dependent case among 4 banks, damages, shortage or deficit of super built-up area and garden area and cost of construction of alluding sliding windows and unnecessary building lane. But as per the terms of agreement of sale, they are ready to provide some other price tag, but they are not provided. Therefore, we are claiming damages. Whatever the terms and conditions and breach of contract and report as on the agreement design development. Second thing, what
is joint venture agreements? What is the meaning of joint venture agreements?
Joint venture agreement is different from joint development agreement.
Yours again. What is the law? What do you mean by joint venture agreements?
Development agreement between the developer and the owner of the property. Here, I will wait for the same on the Supreme Court only move property must be good exclusively in the commerce, trade and commerce. Then only the execution will come to the commercial court. Otherwise, that has to be the jurisdiction. Here also,
the problem is trade and commerce.
Trade and commerce.
Now you are trying to trade your property.
I have given my property to develop the
Kali property.
Yes,
you have traded your property with a developer to get back something developed. To get back something developed. Is it not trading?
It will not come in the meaning of trading. When the development you have, they have also.
What is this? What are the facts of this case?
The matter arises from the district court blood an application under order.
What was the relief sought for in this suit?
Here, based on the agreement of the memorandum of title deeds and mortgage memorandum of understanding entered between the parties on 3/11/2017, and where it got yes, amendment is a mortgage deed also existed by the parties. Under such circumstances, and arising, the dependent credit application under Federal Health, the report has not been rejected for enterprise in matter. The matter comes to operate trade and commerce. Therefore, the matter enters.
You should distinguish between a joint development agreement and a joint venture agreement. If there is a joint development agreement, it may fit into the words joint venture agreement because it's a joint venture between you and the developer.
The definition of commercial disputes are only the joint venture agreement is different from the joint development.
Sure, Sharon.
And see, the of the commercial contract, nowhere it is defined as joint development agreement.
Correct, joint venture agreement. So, how do you understand joint venture? Joint venture and then what is the meaning of joint venture?
To an agreement executed by the party to the
So that's an agreement between two entities. It could be two individuals, it could be two entities. They join together to venture out to do business. They join together to venture out to do some business. In your case, you have joined hands by giving your vacant property to take back something developed. Will it not fit into the definition of joint venture agreements? Of course, please show.
The agreement that is
ಇದರಲ್ಲಿ ಯಾವುದು ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಇಲ್ವಾ?
You only the judgment that if the land, you only judgment that is trade and commerce come one way of trade and commerce, then only commercial court. Otherwise, of the matter what happened in this matter, because the surrounding means very true. Commercial court act is for the meetings not in the office of making expectations. There are no notice by the on the matter set out for stage of evidence announcement properly.
Issue notice. Please serve the learned counsel for the respondent.
Very good.
Issue notice. In addition, the learned counsel for the petitioner is directed to serve the learned counsel who represented the respondent before the trial. List on date. 14 September. Serve ಮಾಡ್ಕೊಂಡು ಏನಾಗಲ್ಲ. Already, the lead every. The BH Nagaraj.
Execution also. And the execution are more documents. The report says to move before the report. Then I think the other Hence, there was no grounds made out with the evidence followed in this. When we took the order to dispose of something. But I have very written arguments also. Written arguments is produced in the correction scene. And the report is passed in the final order on the basis.
Okay, what is the stage now? The argument stage ಅಲ್ಲಿ ಇದೆಯಾ?
Argument stage ಅಲ್ಲಿ written argument let them pass the arguments of merit on the appeal. But very execution. Then execution of the report says to go before the
Therefore, issue notice. In addition, learned counsel also also. Until the next stage of hearing, further proceedings in EP number 70 of 2021 on the file of the 9th additional first civil judge Mysuru in the next stage of hearing. List on 15. So it is, this order of stay will not come in the way of the fourth additional city civil judge and JMFC Mysuru to consider and dispose of fourth additional senior civil judge only. Senior civil judge and JMFC Mysuru to dispose of RA 117 of 21. Vyasara. What is the total outstanding? Extra? You look your conduct because of your mistake, the bailiff is put to difficulty. 50%. 50% money. Therefore, issue notice. In addition, the learned counsel for the petitioners directed to serve the learned counsel who represented the respondent before the trial court, before the executing court. ಅಲ್ಲ ಅಡ್ವೊಕೇಟ್ಗೆ ಇದು ಸರ್ವ್ ಮಾಡಿ ಅಲ್ಲಲ್ಲ ಶುರು ಮಾಡೋ ಒಂದು RPD ಕಳಿಸಿ ಅವ್ರೇನ ರಿಸೀವ್ ಮಾಡಿದ್ರೆ ಐ summon him to the court. Advocates are bound to receive notice. They can't say. They are bound to receive notices. How can they say that? Sir, some good behavior have to be imparted. So therefore we have to impart. We have to force them to learn some good behavior, good practice. Advocate ಆಗಿ ನಾವು ಕಾಪಿ ತಗೊಳ್ಳಲ್ಲ, ನೋಟಿಸ್ ತಗೊಳ್ಳಲ್ಲ ಅಂದ್ರೆ it will be very unfortunate. ಕಾಪಿ ತಗೊಳ್ಳಿ, ಅದೇನು ಆಕಾಶ ತಲೆ ಮೇಲೆ ಬಿದ್ದೋಗೋದೇನು ಆಗೋದಿಲ್ಲ. ಕಾಪಿ ತಗೊಳ್ಳಿ, come to the court and say whatever you want. So therefore, if you file a memo to that effect, I'll summon the lawyer. The impugned order is stayed in the next state of hearing, subject to deposit of 50% of the amount involved. 50% of the amount got to be recovered in execution petition. 10/21 on the file of the principal senior civil judge, principal judge, family court, Udupi. List on date put. By the next date you have to deposit. 16 September. Stay agide, impugned. Proceedings are stayed. Impugned order for arresting. ಇವಾಗ ಏನಾಗಿದೆ? ಫರ್ದರ್ ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದಾರ? ಅದು ಸ್ಟೇ ಆಯ್ತು ಸಾಕಲ್ಲ. ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಸ್ಟೇ ಆಗ್ಬೇಕು ತಾನೆ. ಅಲ್ಲ, ಸ್ಟೇ ಆಫ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಇಂದ ವಾರೆಂಟ್ ಎಕ್ಸಿಕ್ಯೂಟ್ ಆಗುತ್ತೆ, ಅದಕ್ಕೋಸ್ಕರ ಹೇಳ್ತೀವಿ. ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಸ್ಟೇ ಆಗಿದೆ. ಪೊಲೀಸ್ನವರು ಅದೆಲ್ಲ ಯೋಚನೆ ಮಾಡೋದಿಲ್ಲ. ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಸ್ಟೇ ತಂದಿದ್ರ ಅಂತ ಕೇಳ್ತಾರೆ. ಸ್ಟೇ ಆಫ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಏನು? What is this case? Not to alienate is challenged. Partition suit. Correct. It's a very innocuous order, Mr. Not to alienate the property. It's in the partition suit. Does she say about the partition deed in the suit? Has she mentioned about the partition deed? What does she say about it? Nothing. Within 12 years. She could have sought for reopening the partition. What is wrong? What is wrong? ಅಷ್ಟೇ ಅಲ್ವಾ? That's a fact that has to be looked into. In the meanwhile, if you dispose of the properties, ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? That is all. Anything else? Yes. Within 10 days ಹೆಂಗಾಗುತ್ತೆ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಕ್ಕಾಗುತ್ತಾ? ಆಯ್ತು, 4ನೇ ತಾರೀಕು ಆರ್ಡರ್ ಮಾಡ್ತಾರೆ. 14ನೇ ತಾರೀಕು ಒಳಗೆ ರಿಟ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿಲ್ಲ ಅಂತ ಚಾಲೆಂಜ್ ಮಾಡ್ತೀವಿ ಅಂತ ಟೈಮ್ ಕೊಡ್ಬೇಕು. ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ತಿರೋದು. 4/7/22 the court passed an order and it required the PW2 and PW3 to be present on 14/7. He made a request for time to challenge the order dated 4/7/22. Court says I to let him to challenge that order.
Color xerox copy. Along with the print, there are 6 of the print and here with the evidence of the document. Realization that the print for the council, this is the different they are marking of the document. Now, number 6 of the print, the draft stated anything about the production of murder. Suppose the period is regard to
the plain tell you Alexa.
Yes. Page number 24. Error number 6. Page number 22. Error number 6.
Error 6.
Has taken back the original agreement of share dated 37/2018 by yield copy of the share to be taken. And yes, the plaintiff have produced only copy of the agreement of share dated 37/2018 as original of the share is available with the defendant number 1 himself. It is further submitted that in fact at the time of
Before marking this document,
they produce the color xerox. As it is a original.
no, but was an application filed under section 65.
I'll mistake. Even I consider the report also marking the report by way of filing separate. That is
Whatever it is, no. It's a, you should lay the foundation for leading secondary evidence. Could have referred it, sir. If you want this document to be marked, if you want this photocopy of a document to be marked, you should call upon him to produce the document. If it is not there, file an application. So therefore, then you should file an application. And this order has to go. Purple. The petitioners are the defendants 1 and 2. Invoice number 23 of 2020 on the file of the First Additional Senior Civil Judge and J.M.F. Chiblapura, who was challenged an order dated 4/7/2022, by which the court refused to review its earlier order marking a photocopy of an agreement of sale as Exhibit P1. Next paragraph. The suit invoice number 23 of 2020 was filed for specific performance of an oral agreement. Specific performance of a oral agreement and an agreement of sale dated 37/2018 and a further agreement of sale dated 28/6/2019. To stop, it was contended in the plain that an oral agreement was entered into between the parties on 24/10/2016, which was recorded into writing on 37/2018. To stop. Later, a further agreement of sale was dated 28/6/2019 was entered into, on which day the defendant number 1 collected back the original agreement of sale dated 37/2018 and handed over a copy of the same to the plaintiffs. To stop.
That's actually.
It was contended in the plaint that the original agreement of sale dated 37/2018 was lying with the defendant number 1. And that he had handed over a color photocopy of the said agreement of sale. Stop. During the course of evidence, the plaintiff marked this document without resorting to the procedure required under procedure prescribed under section 65 of the Evidence Act. Stop. When the case was set down for cross-examination of PW2 and PW3, the counsel for the defendants raised objection regarding the marking of the colored copy of the agreement of sale dated 37/2018. Full stop. The trial court, in terms of the order dated 3/3/2022, posted the case for orders regarding the marking of exhibit P1. Full stop. Thereafter, the impugned order was passed on 4/7/2022, holding that neither the plaintiffs nor the advocate of the plaintiffs represented against marking the photocopy of the agreement of sale, and that the plaintiffs had laid foundation for secondary evidence. Hence, marking the photocopy of the agreement of sale dated 37/2018 was in order. Full stop. Being agreed by the said order, the defendants have filed this petition. Next, the learned counsel for the defendant submitted that the plaintiffs did not take any steps to lead secondary evidence, and that the finding of the trial court that the plaintiffs had laid the foundation for leading secondary evidence was palpably wrong. Stop. He submitted that since the document dated 37/2018 was a photocopy which was denied by the defendants, it was incumbent upon the plaintiffs to take appropriate steps to mark the said document as secondary evidence. Stop. Per contra, the learned counsel for the plaintiffs submitted that learned counsel for the plaintiffs fairly submitted that plaintiffs had not laid any foundation for leading secondary evidence, and that therefore plaintiffs may be reserved liberty to take appropriate steps to lead secondary evidence and mark the photocopy of the agreement of sale. In that way of the matter, this petition is allowed. The impugned order is set aside. The marking of exhibit P1, marking of the agreement of sale dated 30th of July 2018 as exhibit P1 is recalled. The plaintiffs are at liberty to lay a foundation to lead secondary evidence about the document dated 37/2018. ಆಗ್ಲಿ ಆದ್ರೂ ಆರ್ಗ್ಯುಮೆಂಟ್ ಸ್ಟೇಜ್ ಅಲ್ಲಿ ನೀವು ಆಗ್ತದೆ.
2019 ಇಂದ
ಅಲ್ಲ ಸೆಟಲ್ಮೆಂಟ್ ಹೋಗೋ ಸ್ಟೇಜ್ಗೆ ಏನಾಗಿತ್ತು? ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮುಗಿದೋಗಿತ್ತಲ್ಲ. ನೀವು ಓರಲ್ ಎವಿಡೆನ್ಸ್ ಮಾಡಲ್ಲ ಅಂತ ಹೇಳಿ. If you are not leading oral evidence, I'll permit you to file. If you are not leading oral evidence, no further evidence anta andre, I'll permit you to amend the written statement. Can't do. Sorry. There should be end to litigation alwa, sir. ಇದರಲ್ಲೂ ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ, ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಸಂಗಿದ್ರೆ. Yes. What is the amendment sought for? Right, this is not something that you discovered now. ಹೊಸದಾಗಿ ಗೊತ್ತಾಗಿದ್ರೆ ಹೇಳ್ಬೋದು. At the time of filing the written statement itself, you knew these facts at the time of filing the written statement. How can you wait till the case is set down for argument? Understand? So again, the case will not go back to your evidence.
No, examination.
ಎಲ್ಲಿದೆ? ನೀವು ಹಾಕಿದ್ದೀರಾ? Not after the case is set down for arguments. ಈಗ ಫಸ್ಟ್ ಇಂದ ಶುರು ಆಗುತ್ತೆ. Again, plaintiff has to enter the witness box. He has to give an evidence. ಆಯ್ತು, then if that is the case, then you deposit cost. 50,000 ರೂಪಾಯಿ. Sorry, sir. No, the case cannot go back. Cost cutting, will direct them. This is not a child's play. Maklata alla court in case under. So there should be some amount of seriousness. You knew the facts. You knew how much land was available in your hands. You knew what was the excess land in the hands of the plaintiff. You knew everything. Why did you wait till the matter was listed for the arguments? ನೋಡಿ 50,000 ರೂಪಾಯಿ ಕಾಸ್ಟ್ ಕಟ್ಟಂಗಿದ್ರೆ the request of the counsel for petition is the next Monday. Where is your application? The proceedings in FPP 2 of 2001 on the file of the Civil Judge Senior Division, Mandya State. Madam, Mr. Bhargav. Addition, the learned counsel for the petition is directed to serve the learned counsel who represented the respondents before the final decree court. So the advocates were represented before the decree. This time, 15. Yes. Yes, Mr. ಸಾಲ ತಗೊಂಡಿದ್ ಯಾವತ್ತು? When did you raise the loan? ಎಷ್ಟು ಕಟ್ತೀರಾ ಈಗ? 50%. ಟೈಲರ್ ಯಾಕೆ 10 ಲಕ್ಷ ಯಾಕೆ ಸಾಲ ತಗೊಳಕ್ ಹೋದ್ರಿ ಟೈಲರ್? ಏನ್ 50%. 50%. Why? 50% ಕಟ್ಟಂಗಿದ್ರೆ ಅಷ್ಟೇ. ಈಗ ನೋಟಿಸ್ ಟೈಲರ್ ಇರ್ಲಿ ಯಾರು ಇರ್ಲಿ ಸಾಲ ತಗೊಂಡ್ರು ಸಾಲ ಕೊಟ್ಟು ನೋಡಿ ಮತ್ತೆ ಯೂಸ್ ಮಾಡ್ಬೇಕಾಯ್ತು ಕರೆಕ್ಟ್ ಆಗಿ. ನೀವ್ ಯಾಕೆ ಎಷ್ಟಿದೆ ಟೋಟಲ್ ಅಮೌಂಟ್ ಎಕ್ಸಿಕ್ಯೂಷನ್? 11 lakhs. Deposit 4 lakhs. No. Purple. 12 ಲಕ್ಷ. ಈಗೇನು ಮೂವಬಲ್ಸ್ ಇಶ್ಯೂ ಮಾಡಿದಾರ? ಮೂವಬಲ್ಸ್ ಇಮ್ಮೂವಬಲ್ ಪ್ರಾಪರ್ಟಿ? Issue notice. In addition, the learned counsel for the petition is directed to serve the learned counsel who represented the respondent before the trial court. Full stop. Further proceedings in commercial execution 120 of 2021 on the file of the 10th additional district judge, Bangalore Rural District, Bangalore State, subject to deposit of the sum of rupees 4 lakhs before the executing court within a period of 4 weeks from today. First continue. The HCGP is directed to accept notice for the state. Please serve the copy to the HCGP. List on date. List on date. Okay. Serve a copy to the government lawyer. Start date. 29th August. Serve a copy to the government advocate. The learned counsel for the petitioner submits that the petitioner number 1 is the father. When the petitioner number 2 to 3, 2 to what about 6? 2 to 7, 2 to 5 and 7 are the legal heirs, and therefore seeks dispensation of the requirement of filing a formal application to bring the legal representatives on record. So in view of the submission made, the petitioners 2, 3, 4, 5 and 7 are treated as the LRs of Petitioner number 1. Counsel for the petitioner is directed to make appropriate entries in the constitution. 2 weeks time is granted to bring the legal representative of the petitioner number 6. First, let them bring on record. Interim order granted early is extended to the next date. It is made clear that if steps are not taken to bring the legal representative of the petitioner number 6 on record before the next date of hearing, the interim order extended today shall stand cancelled automatically.
Please appear for the petitioner in this matter. Kindly pray for a day's time. I will pay the process fee. One is to respond.
Counsel for the petitioner seeks time to comply the office objections. 1 week time is granted to do the needful, failing which the petition against R11 and R17 shall stand dismissed.
Much obliged.
A non-filing of wakalat by authority. Again, the facts are in.
Injunction was order decided preliminary got food for declaration and injunction as well as minority. But when they right or
The first petition is for deposit of rents. Admitted tenancy, no?
not tenants, but it is the dependents are encroached on the maintenance property and they constructed a cover, a mobile cover, and is giving the rents to the dependent. And for that is also be deposited in court. That is the application which has been rejected.
The application is annexure, yep. D7. Depend number 7, telecommunication, Nida. Reliance. Yes, what is wrong? Which rent should not be deposited? It could be anybody, Mr. There is a dispute regarding. New Year again. So there is a dispute regarding the property where a tower is installed. Now you are getting the rent from. Could be. There is a dispute regarding that property. So therefore, shouldn't rent be deposited before the court? The guarantee could even over. They give a guarantee on personal guarantee could you give something, then you take the rent.
It is not
Near mill. I to Reliance my order on email to direct Reliance to deposit the money. To direct Reliance to deposit whatever money. The request of the counsel for respondent number 1. Yes. Serial number 21 now. We are at serial number 21. Yes. Take 1 week, madam, but comply. Take 2 weeks, but comply. 2 weeks time is granted to comply the office objections, failing which petition shall stand dismissed without reference to bench. Same order. Same order. Huh? Password. 2 weeks time is granted to do the needful. The counsel for the petitioner submits that the petition may be dismissed as withdrawn. Submission is placed on record and the petition is dismissed as password. 2 weeks time is granted to do the needful. Right? 2 weeks time is granted to comply the office of petition, failing which the petition shall stand dismissed without reference to bench. 2 weeks.
That to permission of the preamble of connection here. Certificate of case what are produced man. Connection here take for. That is one we have to see other application has found. But in this case law, connection here take for. But in this case, the respondent number 1 had filed a suit for declaration and permanent injunction against this petition. US number 3 and 5 of but in this case,
ಯಾವ stage file ಮಾಡಿದ application? At what stage this application was filed?
Application is a formula. The connection will kind of see. Connection D page status. Connection D page status and link there. The petitioner before the summary court has explained the matter is and also has taken a that. However, there are not classes. Classes here is full non-municipal council assessment number. The assessment number has been assigned.
No. Commissioner ಏನಕ್ಕೆ?
ಅದರಲ್ಲಿ even ಅವ್ರಿಗೆ
ಕಮಿಷನರ್ ಇರೋದು ಸುಮ್ಮನೆ ನೋಡ್ಕೊಂಡು ಒಂದು ಬರ್ಡ್ಸ್ ಒಂದು ಬರ್ಡ್
they are at the outset they are questioning that regarding the plan sanctioned by the department. They conclude on PMC, but the PMC has not read the part. But I have to do all the documents for that.
Don't argue the matter on merits. Now the case is set down for cross-exam arguments. At the stage of arguments, an application for appointment of a commissioner is filed. Trial court has allowed that application. Ad sarina tappa yak ಮಾಡಬಾರದು ಅಂತ ಹೇಳಿ.
And my submission become example for that. Since the defendant has taken a specific convention that the property belongs to him, and also the
ಅದು merits ಮೇಲೆ ಆಯ್ತು.
So it is nothing but through this appointment of commissioner, the plaintiff is trying to collect the evidence in the favor.
Evidence is already over.
Literally, because he has to
Evidence
establish that whether the DPP that the PMC have granted the plan and also whether the property belongs to the respondent as stated in the written statement.
Please read the application. Over.
Connection. Keep the connection.
Application over.
Application number 26/1999. That is 151. All the reasons sought to in the affidavit that the above named applicant or plaintiff number 1 is being declared that the sample court is to appoint any advocate or competent person as court petitioner for giving the report in respect of whether the defendant is constructed with house by violating this and a conviction imposed on the license and as well as sketch and also enforcing the exemptions of classes as per the mentioned in the settlement deed and so on. Executed by one order by him. So earlier shortage of administration of the matter is to take about yes the interest of
ಲೈಸೆನ್ಸ್ ಇದೆಯಾ ನಿಮಗೆ? ಲೈಸೆನ್ಸ್ ಇದೆಯಾ?
I have taken a specific attention in the written statement that the competent authority receives the legal municipal council has granted the license. Thereafter, I have constructed the house.
ಸ್ಕೆಚ್ ಪ್ಲಾನ್ ಇದೆಯಾ?
And the plan and license both.
ಸೊ ಆ ಪ್ಲಾನ್ ಲೈಸೆನ್ಸ್ ಮಾರ್ಕ್ ಮಾಡಿದಿರಾ?
ಮಾಡಿದ್ದಾರೆ.
ಅವ್ರು ಕೇಳ್ತಿರೋದೇನು? ಪ್ಲಾನ್ ಲೈಸೆನ್ಸ್ ಪ್ರಕಾರ ಕಟ್ಟಿದಾರೆಲ್ಲ ನೋಡ್ಕೊ ಬರ್ಲಿ.
Because I have taken a specific how do you know there is a charge and schedule kindly situation schedule connection D is is the client. The property khata assessment number. This does say PM should not outline this khata number. Khata number also extend east to west 24 feet, north to south 10 feet, including vacant site and bounded by the roof of the house, bounded on property of the suit item number so property of suit item number 4, Out last the Irangama, and passage and then is good for item. July schedule every item no passage. Items no passage. Next item number 2 passage which runs towards the sponsor. Item number 3 no passage runs towards the sponsor. Item number 4 no not the passage which runs towards the sponsor.
Passage after passage.
Declared he having it is better right control.
Let the commissioner decide. Oh, not company. Work. This petition is filed by the defendant. Invoice number 329 of 2013. As mailed, office objections are overruled. Next, the defendant invoice number 329 of 2013 on the file of the Principal Civil Judge and JMFC Punigal has filed this writ petition challenging an order dated 15/12/21. 15/12/21 passed therein, by which the court allowed an application and order 26 rule 9 of the Code of Civil Procedure and appointed an engineer from the Public Works Department to measure the suits and properties and to report the same. Next, the suit invoice number 329 of 2013 was filed for. What is the suit for? Was filed for declaration. Declaration to declare that the suit item number 1 is a passage. Essential passage is a passage. ಆಯ್ತಲ್ಲ ಏನೋ ಬರೀತಾರೆ ಏನ್ ಮಾಡಕ್ಕೆ ಎಸೆನ್ಷಿಯಲ್ ಪ್ಯಾಸೇಜ್ ಅಂತ ಎಲ್ಲಾದ್ರೂ ಇದೆಯಾ is a right of way to access the property of the plaintiff and for consequential relief of mandatory injunction. Full stop. The suit was contested by the defendants who denied the existence of the passage. So after the suit was listed for arguments, the plaintiff 1C filed an application to appoint a competent person as a commissioner to report whether the defendants have constructed the house as per the license and plan sanctioned in their favor, and also to report about the encroachment on the passage as per the settlement deed dated passage left in the passage shown in the settlement deed dated 5/3/1965. Full stop. The trial court, after considering the contentions in the plaint as well as the written statement as well as the evidence, held that the report of a commissioner is necessary for the effective adjudication of the dispute between the parties. Being agreed by the said order, the present writ petition is filed. Next, for learned counsel for the petitioner submitted that the suit that the passage could not have been identified as assessment number 438/366 as a passage cannot be the subject matter of an assessment. He further submitted that the defendants have denied the existence of the passage and therefore there is no need to appoint a commissioner. Full stop. Further, he claimed that the appointment of a court commissioner would result in collection of evidence which is impermissible. Appointment of a commissioner would result in collection of evidence which is impermissible. Next part. The requirement of appointment of a court commissioner is to be left to the absolute discretion of the trial court. Full stop. If the trial court is of the opinion that the evidence on record is not sufficient to decide the dispute between the parties, it would resort to getting a report resort to appointing a court commissioner to secure the ground realities. Full stop. This is only for the purpose of adjudication of the dispute between the parties and to appreciate the evidence on record. Full stop. In that way of the matter, comma, there is no error in the exercise of jurisdiction by the trial court warranting interference. A resolution lacks merit and is dismissed. You're always at liberty. Liberty is there, the commissioner ಮಾಡಲೇಬೇಕು. Liberty is reserved. Liberty is reserved to all the parties in the suit to file memo of instructions. One week, huh? Madam, there's so many objections. Take 1 week. 1 week time. Varkulu, 1 day time is granted. The learned counsel for the petitioner seeks 1 day's time to comply the office objections. The same is granted. List after office objections are complied. List after service of notice to R7. Interim order diya. Interim order is extended in the next date of hearing. Pass over. Office objections. What is the note? What is the note? Office objections along with CP note. What is CP note? Favorite petition. Note below the cost title. What is note below the cost title? Yes, what is the issue? Issue notice. Yeah, figures in here. This one number 1. So why don't you give the NOC? It's a fact. So be ready. Be ready to face adverse consequences. When did you make the request? When did you make a request for the no objection? When did you request him to give the no? Please wait.
Mentioned that he requested he can compromise paid. He had also mentioned.
When did you file the application before the trial? When did you file the application to engage another advocate?
In 9/3/2022.
On 9th of March. When was the
Payment by the NOC, but it was rejected by the trial court.
Yes.
This matter is covered by the judgment of this court.
No, we are not on that. When did you make an application? 9/3/22. Yes. At what stage? Evidence of? You cross-examine. Who are you? Please sit down. Mister, you please sit down. Hello. Please write. Who is the Seenappa? Seenappa is which defendant? Seenappa is which defendant? Seenappa. What are you represented Seenappa? What are you have cross-examined the plaintiff on behalf of Seenappa? You have cross-examined. On behalf of Seenappa, have you cross-examined PW1? Evidence agide avrdu. Seenappa ಅವ್ರದ್ದು evidence. Seenappa the evidence ಮಾಡಿದೀರಾ? ಯಾವತ್ತು different evidence ಯಾವ್ದು ಆಗಿತ್ತು? Further different evidence ಯಾವ್ದು? Defendant number 4 present. Finally say about the NOC of D4. Yes, Mr. What is this? No, what is this? Lawyer, idonde case irad ninge. Alla, is this the only case you have? Court, Mr. If some other lawyer comes, please wait. Please listen to me. One ನಿಮಿಷ ಕೇಳ್ರಿ. ಯಾರಾದ್ರೂ ರೋಡಲ್ಲಿ ಕೆಲಸ ಮಾಡೋರು ಒಂದು ಬೈದ್ರೆ ಸರಿ ಕೆಲಸ ಮಾಡಕ್ ಬರಲ್ವೇನೋ ಅಂತ ಬೈದ್ರೆ the next day onwards he will not come. ಕೆಲಸ ಮಾಡೋನೆ menial employment. The person doing a menial employment, if you scold him, he will not come the next day. Somebody comes and tries to represent on your behalf in your place. First NOC ಬರ್ದು ನೀವು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇಸಿಬೇಕಿಲ್ಲ. Fog and Allah. Somebody comes and says, give me the no objection. You should throw the no objection on his face. Please give the no objection now. Give the no objection, Mr. Mr. Please give the no objection. ಅದನ್ನ ನೀವು ಚಾಲೆಂಜ್ ಮಾಡ್ಕೊಳ್ಳಿ. That is your, sir. You must have collected your fees then and there itself. If you have not done it, I don't know what is the agreement between you and the defendant number 4. ಏನೇನು ಅರ್ಥ ಮಾಡ್ಕೊಂಡಿದ್ರೋ ಗೊತ್ತಿಲ್ಲ. What is the understanding ಗೊತ್ತಿಲ್ಲ. ಸೈಟ್ ಕೊಡಿ, ಮನೆ ಕೊಡಿ, ಏನೇನೋ ಇರ್ಬೋದು. We do not know. If you want a site, fight it out with him. If he doesn't want to engage your services, what is this? Very, very shameful, utterly shameful. Please give the no objection, otherwise we'll send it to the bar council if you want. Please give the no objection now. Is he present? Please keep him present. Yen idella, this is, you are pulling down the profession to such. Ready already, bisakbeko, mukudna bisakbeko ಅಂತ ಕರೆದ್ಬಿಟ್ಟು. ಕೊಡಲ್ಲ ಅಂತ ಹೇಳಿದಲ್ಲಪ್ಪ, ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳ್ತಿರೋದು ನಿಮ್ಗೆ. ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳ್ತಿರೋದು, ಕೊಡಲ್ಲ ಅಂತ ಹೇಳ್ತಿರೋದಲ್ಲ. First thing you should do is call him, throw the NOC on his face. ಬೇರೆ ಕೇಸ್ಗಳು ಬರಲ್ಲ ನಿಮ್ಗೆ. Is this the only case you have? ಈ ಭಾನುವಾರ ನಿಮ್ ಫೈಲ್ ಎತ್ಕೊಂಡು ಹೋಗಿ ಗೊತ್ತಾಗ್ತದೆ. ಬಾರ್ ಕೌನ್ಸಿಲ್ sits only on Sundays. Keep the lawyer present. Mr. Armugam. Complaints of office objections. Yes. 11 office objections, sir. 11 office objections, please go through. 2 weeks time is granted. 2 weeks. Right, 1 week time is granted at the request of the learned counsel for the petitioner. List after service of list after complaints of officer.
Plus 34, it may kindly be passed out.
For what, sir?
Now, only one page is missing from Annexure A, which I had taken the certificate copy from the trial court. Lots of my, I'm making it available notes along with a memo. Kindly pass it.
You complete. Your colleague is here.
Yeah,
The colleague-
kindly accept the memo, please.
Learned counsel for the petitioner has placed on record the complete set of Annexure A. So the same is accepted. Is the petition tomorrow?
Grateful.
Yes. 2 weeks time is granted to do the need.
My lord, I appear for the petition. This is the petition made against the order of rejection of application under Order 7 Rule 11D.
CRP ಹಾಕ್ಬೇಕಲ್ವಾ?
It would not amount to. It would not
Should
amount
order.
to.
It amounts to a case decided, sir.
No, it is a rejection of application. I understand, madam, if it had been allowed.
Correct. Rejection of the CRP, because allowing the CRP would result in disposal of the suit.
Well, my lord, well, I shall CRP conversion. Your lordship, kindly permit me to.
No conversion, sir. File a fresh petition. The impugned order is passed under Order 7 Rule 11D. The impugned order is an order of rejection of an application under Order 7 Rule 11D, which is revisable under Section 115 of the Code of Civil Procedure. Hence, the office objection raised regarding maintainability of the petition is upheld. The petition is dismissed. It is open for the petitioner to file the revision petition.
Much
It's the option to return certified copy of the impugned order after retaining a photocopy of the same.
much.
Yeah, recalling it. What is this recalling the order dated 11/3/22? Yes. Number 3.
He is also
3 is allowed. 8 is also allowed. What you want it?
before now, people need to bring all the stuff on record. If every time you bring the other operation, all the other.
Yes.
Over that time, how they want to find order.
What you do?
Bring them down.
You make him as a respondent, Mr. You arrange him as a respondent. You bring him on record as a respondent. Because tomorrow you cannot say that this order was passed without his knowledge. Let him come to the court and waive it off. He cannot sit outside the court and say I waived off. Let him come to the court. Who has waived off? The son of the appellant number 8. Hold. IA 1 of 22 is filed to recall the order dated 11/3/2022. It is stated the applicant in this application is the appellant number 8. Full stop. He stated that his father died on 4/9/2012. Leaving behind the appellant number 8 and his brother Ramanjani. Full stop. The appellant has claimed that The said Ramanjani has separated from the family and has relinquished his share in the property in question, and therefore is not interested in joining to represent the estate of the deceased father of his deceased father. Full stop. This court had passed an order dated 11/3/2022, allowing IA number 1 of 16, which was an application filed by the legal representatives of the deceased appellant number 8. To stop. This court had granted liberty to the applicants to file appropriate application arraying all the legal representatives of the deceased appellant number 8. Stop. The applicant now claims that since his other brother is not interested to join in prosecuting this appeal, the requirement of including him as one of the legal representatives may be recalled. If the deceased if the appellant number 8 has left behind any legal heirs, they are bound to be brought on record. Full stop. If one of the legal representatives of the deceased appellant number 8 has filed IA 1 of 2016, this court had rightly directed him to array all the legal representatives of the deceased appellant number 8. Full stop. Therefore, the order dated 11/3/2022 is just and proper and cannot be recalled. It is, however, open for the appellant, the LR of appellant number 8, to file appropriate application to implead his brother as a respondent in this appeal. Nandan Nilwal, not before me. So how can I fix the date for another judge who is dealing with this matter? Our Munda was you careful. Same order in the other 37.1 Same. Yes.
Appear for the appellant, my lord. Suit for declaration and
Recalling in.
although I'll file objections, my lord. I had impleaded these persons as party respondents and also taken an interim order by this honorable court. And now they are asking for that order to be recalled. I'll file my objections, my lord. May kindly. I'm sorry.
12/4/2021, IA 1 of 2018 shall be called, considered along with the main appeal. Interim order granted earlier, if any, shall be extended till the further orders. Ian is recalling anything.
So, maybe who is dismissed, controlled by the appellate court and before finding the appellant himself makes an application that's already present. So this court has passed an order. The application has to be made. That order ought to be required to be present.
You are a purchaser even before the suit was filed.
So the reason is by taking advantage of the meeting order, so they are trying to interfere with the party. Therefore, I made an application to recall that particular order. To allow that particular application. And also I made an application seeking an injunction.
You don't have objection to allow this IA 1 of 2018.
Yes.
You have no objection to allow
I
it.
have no objection to allow the application. I have no objection to allow it. If I come on record,
My application for the injunction, still applied from injunction.
Purple. Any objection to allow this application? IA 1 of 2018. It's filed by you only.
ನಾನು object. My lord, I have no objection. ಇದು ಅವ್ರ ಫ್ಯಾಕ್ಸ್ ಹೇಳಿರೋದು ತಪ್ಪಿದೆ ತಾವು ಅವಕಾಶ ಕೊಟ್ರೆ 2 ಸೆಂಟೆನ್ಸ್
IA 1 of 2018 is filed by you to implead this person. This person has no objection to allow that application.
Grateful, man. Grateful. But the TI also order is also there. I request my lord to kindly extend.
TA will be extended because it's already extended until further orders. So let him file an application for vacating stay or whatever. Whatever. File an application for modification, do whatever you want. IA 1 of 22 is trying to recall the order for 2020. Full stop. The order dated 12/4/2021 discloses that IA number 1 of 2018 was ordered to be considered along with the main appeal. Was ordered that discloses that this court passed an order. Discloses that this court passed an order holding that IA 1 of 2018 would be considered along with the main appeal. Full stop. The learned counsel submits that IA 1 of 2018 was filed to implead the party purchased the suit properties even before the suit was filed. Full stop. He submits that he has no objection for IA 1 of 2018 to be allowed in that view of the matter, without disturbing the order dated 12/4/2021. IA 2018 is allowed and the proposed respondent is ordered to be brought on record. Counsel for the petitioner is directed to amend the cost title. It is open for the proposed respondent to file appropriate application seeking modification of any interim order that may be granted in the present appeal. Yes.
Great.
Additional grounds. What is the application which is rejected? Additional issues. So what is the additional grounds that you urged?
Yes, and that third party gets in some period he also files a complaint seeking a company for preparation after rejecting the additional.
What are the additional issues, ma'am? Where's the application? You are for the defendant number 5. You are for the plaintiff. Please sit down. Not necessary, madam. Please argue the matter on merits. Yes.
They were
Where are reading? No, please let us see what is your counterclaim. What is the counterclaim of the defendant number 5?
page number 24 and Injunctions. Number 5. Defendant number 2 is allegedly the so in title of defendant number 5.
Let us see the counterclaim.
Now the counterclaim starts from page number 39, paragraph 27.
39.
And it should be in the page number 2.
Okay, this relates to KG Battery. This property is in KG Battery. ಅದೇ ನಿಮ್ಗೂ ನಮ್ಗೆ ಯಾವ್ದು ಇತ್ತಲ್ಲ ಕೇಸ್ ಯಾವ್ದು ಹಾ ಎಂದೇ ರಾಮಚಂದ್ರನ್ ತೀರೋದಲ್ವಾ ಇದಲ್ಲ ನಾಟ್ ಬಿಫೋರ್ Is there an order? Is there an interim order? Is there an interim order in force? Is this petition before any other court after obtaining orders of the Honorable Acting Chief Justice? Interim order, if any, is extended till the next date of hearing. ನೀವು ಹೇಳ್ಬೇಕಲ್ಲ ಕೆಜಿ ಬ್ಯಾಟ್ರಿ ಅಂತ ಹೇಳಿದ್ರೆ I would have said not before. No, he knew it because I and he were fighting a litigation. Now, R6 notice ಹೋಗಿದ್ಯಾ? Issue notice on IA 1, 2 and 3 of 2022. Yes, release of amount in. No, it says shall continue subject to the rider that the amount so deposited shall not be withdrawn by anybody Yes. What is this rent? Do you have any objection to release the rent, madam? What is this? What is this order passed on regarding deposit of? What is the source for? Who are you? How are you related to this lady?
And I am also one among them. My should not
At the Indian group.
we are all, there is another real number. Of course, all the conventions, 5.5 written statement. We have a petition to sue as an efficient person, that application was rejected and you direct. Thereafter, due to my.
Now the rents are being deposited by State Bank of Mysore. So let them continue to deposit. Yes, yaar ಗೆಲ್ತಿ. Withdraw ಅಂದ್ರೆ ಏನು? ಇಲ್ಲಿ ಸರ್ ನೀವು ಒಂದ್ಸತಿ ಆಗುತ್ತೆ ಮಿಸ್ಟೇಕ್ ಆಗಿದೆ ಏನ್ ಮಾಡಿ. What is your, how can you claim this rent? ಇಲ್ಲಿ ನೀವು ಬಿಲ್ ಪ್ರೂವ್ ಆಗಿಲ್ವಲ್ಲ. ಬಿಲ್ ಪ್ರೂವ್ ಆಗಿದೆಯಾ ಸರ್? ಬಿಲ್ ಪ್ರೂವ್ ಆಗಿದೆ. ಬಿಲ್ ಪ್ರೂವ್ ಆಗದೆ ಹೊರತು how can you, how are you entitled for? ಆಯ್ತು ಇರ್ಲಿ. Yes. Yes. Sir, have you proved the bill? Have you proved the bill? Sorry, Prakul. A1 of 22 is filed for releasing the amount deposited by the respondent number 2 and 3 before this court. Before this court. Stop. The dispute relates to a property which is in possession of the respondents 2 and 3 as a tenant. Stop. While the respondent number 1 claims to be a legatee, the petitioner also claims to be a legate and will. Stop. Will of Srimati. IT early, yes. Of Srimati Vajra Nagaraj Murthy. Of Srimati Vajra Nagaraj Murthy. Stop. Therefore, unless there is a clear finding as to who is the legatee of Srimati Vajra Nagaraj Murthy, the question of releasing the amount deposited by the respondents 2 and 3 herein does not arise. Since IA 1 of 22 for releasing of the amount is rejected. Next, learned counsel for the petitioner is granted 2 weeks time to take steps to bring the legal representatives of the deceased petitioner, failing which I could be failing which the appeal, failing which the petition shall stand abated. Yes. IA 1 for vacating. By the
the respondents in the prior of declaration of title and comment. The evidence of the comment immediate before the was recorded of immediate 2021 when the matter is put at the stage of final hearing. The respondent filed an application seeking amendment to the plea. Contending that they want to insert a prayer for declaration on the ground of adverse. The affidavit accompanying the application, there is no whisper about exercise of due diligence.
Due diligence in Bantu, adverse possession could not have claimed as a main relief earlier because of the judgment of the Supreme Court in Grewal. Now you can also claim for adverse possession.
But adverse possession relief cannot be granted.
Whether you will need any further oral evidence. Let him whatever he wants to do, let him do it. ತಿರ್ಗಾ ಇದೊಂದು ಇವತ್ತಲ್ಲ ನಾಳೆ ಒಂದು ಗೂಬೆ ಯಾಕೆ ಕುತ್ಕೋಬೇಕು ಮೇಲೆ. Let him exhaust all his remedies. ಸ್ವಲ್ಪ ಕಾಸ್ಟ್ ಜಾಸ್ತಿ ಮಾಡೋಣ. ಯಾವ್ದದು? ರೇವಾಜಿತು ಅಲ್ಲ.
As a general rule,
Mr. Earlier, the law was only in a suit for possession you can seek adverse possession.
we use only as a shield, but not as a sword.
You know everything then.
Here, the relief of adverse possession do not have been sought because there is that they have treated this at the time of filing this suit itself. They
Yes.
have referred to paragraph number ones. And they say that.
Because at that point in time, they couldn't use it as a sword. Now they want to use it as a sword.
However, the limitation aspect of this.
Limitation, no.
Hard value.
No, no.
Because they say that the defendant interpret immediate development pattern. They are seeking amendment in the year 2020.
Every day, mister. Every day is a cause of action for adverse possession.
So when the right to sue and cause of action arose, they should have filed it within 3 years.
Right? Just
That has
cost.
not been.
Just cost. Yeah, earlier property. Where is this property? Very correct. Huh? 5 ಎಕರೆ ಎಷ್ಟು 10,000 ರೂಪಾಯಿ 10,000 ಏನ್ ಮಾಡಕ
They are the agreement holders to the right of.
ಸೊ 5,000 ರೂಪಾಯಿ ಎಲ್ಲ ಅಂತಾರೆ ಫ್ರೀ ಬೈಟ್ ಅದು ಇವಾಗೆಲ್ಲ ಬರ್ಕೊಳ್ಳಿ. Yes.
They are claiming under an alleged agreement, but there is no title.
No oral evidence. No oral evidence, no documentary evidence. This petition is filed by the defendant in OS number 363 of 2013 on the file of the additional civil judge in JMFC Terikere. Was challenged in order dated 15/3/2022 passed therein, by which his application and order 6/17 of CPC was read. Sorry. Sorry.
This challenge was
Sorry. Petitioner is the defendant. Was on the file of this counsel was challenged in order dated 15th March 2022, by which an application filed by the plaintiff and plaintiffs in order 6/17 of this code of civil procedure was allowed. OS number 363 of 2013 was filed for declaration of title of the plaintiff and for consequential injunction restraining the defendants from interfering with the possession of the plaintiffs in the suit's real property. The suit was contested by the defendant who denied the title of the plaintiffs. He contended that the plaintiffs were not in possession of the suit property and therefore were not entitled to any protective order of injunction. Stop. And the case was set on for arguments on the main suit. An application was filed by the plaintiff for amendment of the plaint to introduce the relief of declaration that they had perfected their title by prescription. Full stop. The said application was allowed by the trial court in terms of the order dated 15/3/2022. Being agreed by the said order, the defendant has filed this petition. The learned counsel for the petitioner submitted. Learned counsel for the defendant submitted that the application was filed at a very belated stage and therefore the same was not maintainable. He further contended that the plaintiffs had specifically pleaded about their adverse possession in the plaint and therefore they must have sought for the relief of adverse possession at the earliest point in time. Full stop. Per contra, the learned counsel for the plaintiff submitted that the relief of adverse possession could not be used as a sword but as a shield until the judgment of the apex court in the case of Grewal versus into the Grewal and the we therefore submitted that the plaintiffs were entitled to seek amendment to introduce the relief of declaration of their prescriptive right by adverse possession. Full stop. Next para. Consider the submission made by the learned counsel for the parties. It is no doubt true that the relief of adverse possession could not be raised as a substantial relief in a suit filed by the plaintiff, but could be used as a defense in a suit for recovery of possession. However, in view of the judgment of the apex court in the case of Grewal, the relief of adverse possession could be claimed by the plaintiff in the suit. Stop. As rightly contended by the learned counsel for the defendant, the plaintiffs having pleaded about their adverse possession in the plaint must have also sought for the relief of adverse possession, unmindful whether the law permitted such a relief to be sought or not. However, having regard to the controversy between the parties and in order to effectually and finally adjudicate the dispute between the parties, it was appropriate that the amendment application filed by the plaintiffs was to be allowed. Stop. The trial court has precisely done the same by allowing the plaintiffs to plead the relief of adverse possession. Full stop. There is no error apparent on the face of the record. However, the trial court, while allowing the application, imposed cost of ₹100, which was not commensurate with the inconvenience cost to the defendant in the suit. Hence, the cost imposed by the trial court is enhanced to a sum of rupees 10,000. It is made clear that the plaintiff shall not lead any oral or documentary evidence, and the trial court shall decide the case on merits after allowing the amendment sought for by the plaintiff. All contentions are left to. Are vacating stay, yaar. Yes, come on, merits, Mr. Merits, Mandali. Mister, when you came before this court, we granted you an interim order without asking for the arguments. Now, when the respondent files an application for vacating stay, you come up with all these technical arguments. Resign rakbeku, count rakbeku. Come on, merits, mister. Come on, merits. We'll grant you time, but we'll vacate the interim order. Please argue. Please argue. Password. Stay ತಗೋವಾಗ ಎಷ್ಟು ಮುತುವರ್ಜಿಯಿಂದ ತಗೋತಿರೋ ವೆಕೇಟ್ ಮಾಡುವಾಗಲೂ ಅಷ್ಟೇ ಮುತುವರ್ಜಿಯಿಂದ ಆರ್ಗ್ಯೂ ಮಾಡಿ. You should show the same sincerity, mister. ವೆಕೇಟ್ ಆದ ಬಂದಾಗೂ ಅಷ್ಟೇ ಸಿನ್ಸಿಯರಿಟಿ ಬಂದು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬಹುದು. Password. Mr. Sidmallap. I do not know.
Lord, can I submit, my lord? Can I submit? I'm sorry.
Let him come. Yes, 44. Yeah.
Lord, affidavit is ready, my lord, and my colleague is, my lord, submitting the affidavit, my lord, directly to the court, my lord. He may be permitted to, my lord, file the affidavit. Furnishing, my lord, the details of the legal heirs.
Why don't you give the postal address of all these people, sir?
Lord, the postal address, Lord, the Basava Kalyanam, Lord, the name is sufficient, Lord. It is not a big city, Lord.
Baso Kalyana nee hogilla, naan hogidini.
ಅವ್ರು ಕೇಳಿದಕ್ಕೆ ಫ್ಯಾಮಿಲಿ ನೇಮ್ ಇದ್ರೆ ಸಾಕು, ಅದು ಅಡ್ರೆಸ್ ಸರ್ವಿಸ್ ಆಗುತ್ತೆ. ಡೋರ್ ನಂಬರ್ಸ್
ಅಡ್ರೆಸ್ ಕೊಡಿ.
ಪೋಸ್ಟಲ್ ಅಡ್ರೆಸ್ ಇದು ಇಬ್ರು ಹುಬ್ಳಿನಲ್ಲಿ ಇದ್ದಾರೆ, ಇಬ್ರು ಹುಬ್ಳಿನಲ್ಲಿ, ಒಬ್ರು ಬಾಂಬೆನಲ್ಲಿ ಇದ್ದಾರೆ. ಕಲ್ಯಾಣ
ಅವ್ರನ್ನ ಫೋನ್ ಮಾಡಿ ಅವ್ರ ಪೋಸ್ಟಲ್ ಅಡ್ರೆಸ್ ಕೊಡಿ.
ಕೊಡ್ತೀನಿ. I'll secure it. I'll file a memo with the detail.
Any information about my father's assets owned or left out. My relationship with the other family members of our father's family is not so affectionate or cordial. Vijayalakshmi died. Death of my mother, she had not inherited any property. No, you should make a straight statement whether your father had any property or not.
Lord, he had property, and because
sir, no, this is not the way to do it.
No, I may have pardon to say, Lord, the thing is, as he left, Lord, the family in the year 1994 itself, Lord, from that, Lord, he could not have any information, personal information. He is making his efforts, Lord, to search out, Lord, to know about the particulars of the property. Lord, even he has filed application, Lord, before the executing court also. He has, Lord, given information about the legal heirs. That application has not been considered by the executing court also.
Yes.
Same information I have given, Lord, by filing an application.
Now, this affidavit does not, it's not forthright. It doesn't contain any information.
Lord, I may be excused, Lord.
It's not an honest disclosure.
ಇಲ್ಲ ನಾನು ಮೆಮೊ ಹಾಕ್ತೀನಿ, ಪೋಸ್ಟಲ್ ಅಡ್ರೆಸ್ ಕೊಟ್ಟು ಮೆಮೊ ಹಾಕ್ತೀನಿ.
ಮೆಮೊ ಹಾಕದಲ್ಲ. You should give some information about your
Details. Address I will furnish by filing a memo.
Properties ಕೊಡಿ. Give the details of the
ಪ್ರಾಪರ್ಟೀಸ್ ಅವ್ರಿಗೆ ಪ್ರಾಪರ್ಟೀಸ್ ಡೀಟೇಲ್ಸ್ ಗೊತ್ತಿಲ್ಲ. ಬಸವ ಕಲ್ಯಾಣದಲ್ಲಿ ಅವರಿಗೆ ಲ್ಯಾಂಡೆಡ್ ಪ್ರಾಪರ್ಟಿ ಇತ್ತು ಅಂತ ಗೊತ್ತು, ಬಟ್ ಅದು ಡೀಟೇಲ್ಸ್ ಸಿಗ್ತಾ ಇಲ್ಲ. ಈಗ RTC ನಲ್ಲಿ ಈಗಿನ ಪ್ರೆಸೆಂಟ್ RTC ನಲ್ಲಿ ಅವ್ರ ತಂದೆ ಹೆಸರು ಯಾವ್ದ್ರಲ್ಲೂ ಬರ್ತಾ ಇಲ್ಲ. I made out lot best effort to know about that. Something has gone out of control, not in the
At
family.
least why don't you take a statement that your father had got some properties in Basava Kalyana?
Lord, I'll make out. Lord, I've instructed my party not to get that, but he is effort.
Paper people publish once seeking information. ನಿಮ್ಗೋಸ್ಕರ amicus curiae ಇಟ್ಟಿದ್ದೀವಿ.
Straight away I can consider him, Lord, that he had some property.
Yes, the father's place. This property is attached now.
All properties are also standing in the same hand.
So what is the order passed by the executing court now?
Lord, they have issued arrest warrant against me.
Correct ಆಗಿ ಮಾಡಿದ್ದಾರೆ.
ಅಲ್ಲ, ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಈ ಇಲ್ಲೇ ಪ್ರೀವಿಯಸ್ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಅರೆಸ್ಟ್ ವಾರೆಂಟ್.
Somebody who's hoodwinking the process of the court.
No, I never, Lord, did that, Lord. I am fair enough to the court. I'm from the beginning, I am not disclosing that, Lord. I had my problem.
The court has to decide whether you are fair or not. You can't decide it for yourself.
No. I'm saying that, Lord, to the extent of my knowledge is concerned, Lord, I am submitting. Lord,
knowledge. I thought, in which village your father has left in a property?
Lord, no. My thing is, Lord, I can fairly submit, Lord, at Basava Kalyana, he had some property, agriculture land. But details, ಈಗ ಅವ್ರ ಹೆಸರಿನಲ್ಲಿ ಏನು ಸಿಗ್ತಾ ಇಲ್ಲ. ಅದು ನನ್ನ ಪ್ರಾಬ್ಲಮ್. I could not secure, Lord, particulars of the property he owned earlier. Lord, 5 years, Lord, he was in coma.
Where was this arrest warrant served on you? ಯಾವ ಅಡ್ರೆಸ್ ಅಲ್ಲಿ?
ಅಲ್ಲ, ಏನಿಲ್ಲ, ಈಗ ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ, ನನಗೆ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಇನ್ನು. ಅರೆಸ್ಟ್ ವಾರೆಂಟ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ. Though I was present in the court.
ಆಯ್ತು, ಲಕ್ಷ್ಮೀ ನರ್ಸಿಂಗ್ ಹೋಮ್ ನಿಯರ್ VRL ಬಸ್ ಸ್ಟ್ಯಾಂಡ್, ಈ ಪ್ರಾಪರ್ಟಿ ಹೆಂಗ್ ಬಂತು ನಿನ್ಗೆ?
ಅದಿಲ್ಲ, ಅದು ನನ್ನ ಪ್ರಾಪರ್ಟಿ ಅಲ್ಲ. ನರ್ಸಿಂಗ್ ಹೋಮ್ ನಂದು ಇದು ಯಾವ್ದು ಶಾಪ್, ಮೆಡಿಕಲ್ ಶಾಪ್, ಇದು ಕ್ಲಿನಿಕ್ ಅದು ಆ ಪ್ರಾಪರ್ಟಿ ಬೇಕಾದ್ರೆ ನಾನು ಡೀಟೇಲ್ಸ್
ಅರ್ಥ ಆಯ್ತು.
ಹಾ,
Is it a rented shop?
ಇಲ್ಲ, ನಾನು ಆ ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಟ್ಬಿಡ್ತೀನಿ. ಅದ್ರ ಸಂಬಂಧ ಇದ್ದು ನಾನು ಡಾಕ್ಯುಮೆಂಟ್ ಕೊಡ್ತೀನಿ. ಅಥವಾ ನನ್ನ ಹೆಸರಿನಲ್ಲಿ ಏನಾದ್ರು ಡಾಕ್ಯುಮೆಂಟ್ ಇದೆ ನೀವು ಫರ್ನಿಶ್ ಮಾಡಿ, ಐ ವಿಲ್ ಸಬ್ಮಿಟ್ ಇಟ್.
Please furnish the details of all the family members along with their postal address.
Postal, please.
Pass over. I will only pass it over.
ಅಲ್ಲ, ಈಗ ನಾನು I have to call him. He left.
Call ಮಾಡಿ ಎಲ್ಲ ಅಡ್ರೆಸ್ ತಿಳ್ಕೊಂಡಿರ್ತೀರಾ ಸರ್ ನೀವು. The way you have drafted the affidavit gives an impression that you deliberately not disclose their addresses. Deliberately.
ದಯವಿಟ್ಟು ತಾವು ಆಪದ ಉಪಯೋಗಿಸಬೇಡಿ. I am not.
ಆಪದಲ್ಲ ನೋಡಿ, she lives in Hubli.
ಇಲ್ಲ, no. He came yesterday. He was with me. Morning after getting affidavit, he left. He was supposed to attend a surgery. For that reason, he left.
Yes.
ಈಗ ನಾನು ಫೋನ್ ಮಾಡಿದ್ರೆ ಅವ್ರೇನಾದ್ರು is on the way. I can feel that he is on the way.
Please do whatever you want. Sir, last day too ನೀವು ಹೇಳಿದ್ರಿ, I did not expect this from you.
ಇಲ್ಲ, ನಾನು ಅವ್ರಿಗೆ ಕಾಲ್ ಮಾಡಿದ್ಮೇಲೆ ನೆನ್ನೆ
I will also not expect this from you by giving half-hearted information.
Please.
Don't give a half-hearted information. If you want
ನಾನು ಕೊಡ್ತೀನಿ. ತಾವು ಅಟ್ಲೀಸ್ಟ್ ಅಲ್ಲ, ತಾವು ನಾಳೆಗೆ ಹಾಕೊಳ್ಳಿ. ನಾನು ಡೈರೆಕ್ಟ್ ಅಟ್ಲೀಸ್ಟ್, ಯಾಕಂದ್ರೆ ಆತ ಆನ್ ದ ವೇ ಇದ್ದಾನೆ. ಈಸ್ ಆನ್ ದ ವೇ ಬ್ಯಾಕ್ ಟು ಹುಬ್ಳಿ.
The petitioner has filed an affidavit giving the details of his siblings However, he has not furnished the postal address, neither the postal address nor the contact telephone numbers of the said persons. He has also not disclosed the particulars of the assets left by his father. Though he orally contended that his father had possessed some properties at Basava Kalyana, the affidavit is incomplete and does not contain the required particulars, and therefore the same is rejected. A last opportunity is granted to the petitioner to furnish the postal address and the contact telephone numbers of the siblings of the petitioner. He shall also furnish the property details, the details of the property left behind his father in a period of 1 week from today. Yes, failing which the interim order granted by this court shall be reconsidered. Full stop. List on ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ.
ತಾವು ಡೇಟ್ ಕೊಡಿ ಸ್ವಾಮಿ. ಒಂದ್ ವಾರ ಅಂತ ತಾವ್ ಹೇಳಿದ್ರಿ. ಐ ವಿಲ್ ಬಿ ವೆರಿ ಗ್ರೇಟ್ಫುಲ್ ಟು ದಟ್.
ನೀವು ಒಂದಿನ ಕೇಳಿದ್ರಿ, ಒಂದ್ ವಾರ ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
ಅದಕ್ಕೆ ಐ ಆಮ್ ಸೋ ಗ್ರೇಟ್ಫುಲ್.
ಯಾವತ್ತು ಬೇಕು ಹೇಳಿ. ಮುಂದಿನ ಸೋಮವಾರ.
ತೊಂದರೆ ಇಲ್ಲ.
ನೆಕ್ಸ್ಟ್ ಮಂಡೇ. We shall also furnish the property details of the properties that stand in his name. Yes, evening it will be done. Interim order is extended till the next date. Yes. Condoning the delay. What is the date of the decree? In case it was transferred to Chamarajanagar. What is the court done now? What is the court done now? So issue notice further proceedings in EP number 70 of 2017 on the file of the senior civil judge and James the state. List on the issue notice and in addition the result notice list on 19th September. Neeraja Karan. Yes. Yes, shoot plan. What is shoot property? What is the nature of injunction? Not to interfere. RTC. The RTC arrest.
Now we have to page number 70. We start saying it is executed by Nagama. Page 70. Relevant page number 75 is schedule of proceedings.
Yes.
ಈ ಜಮೀನುಗಳು ಮೂಲದಲ್ಲಿರುವ ಅನುಕೂಲ ದೇವಸ್ಥಾನ ಸಹಿತ ಜಮೀನುಗಳ ಹಿನ್ನೆಲೆ ಸಮಗ್ರ ಮಾಮೂಲು ನೀರು ಗಾಳಿ the living depends are not my vendor. So they are trying to improve the property. When they try to reduce the second one is that the vendor has initiated the deficiency pact for cancellation of the saving. In that state, in that proceedings is responsible for that, and it shows that the vendor is I would say
Now, how is this Nagamma related to this?
yes, Nagamma, how Nagamma is related is that Nagamma's wife, I would say Nagamma's husband name is Monayagoda. Monayagoda and the mother of her friend are brothers and sisters. This is how the relationship continues.
Mother of the mother of D1. Mother of D1 and
Mother of D1 and husband of Nagamma.
Husband of Nagamma ಹೆಸರೇನು?
Monayagoda.
Monaya. Monaya.
So, what the difference contention is that there is a temple and Lakshmi is created. They are in Bharuch. There is a stand. My submission before my Lord is that the temple is really includes the temple includes. Apart from that, they also made an application for grant of land. Page number 107. They made an application.
No. See, what happens is something like this. Suppose if a father is dead and if he is buried in a joint family property, and thereafter the properties are divided. Now, that portion will obviously fall to one person. Can you restrain the others from entering your property? There's a temple, mister. There's a temple. People should come there, should worship. And they would have been allowed to worship over the years. Suddenly you purchase a property, you don't allow people to worship in the temple.
And there are only four other numbers.
The temple ಯಾವ್ದಲ್ಲಿದೆ?
Temple page number 53 finding ಪ್ರಕಾರ ಸರ್ವೆ ನಂಬರ್ 35/815 ಸ್ಪೀಡ್ ಇದೆ. KC page number 50. Page number 53.
Yes, madam. Other than this temple, what is your right? Whom do you represent? We'll grant injunction with respect of all the suit properties except the temple. You're not concerned. You're not concerned, madam.
I'm not concerned, but there is a
ಆಯ್ತು ಬಿಡಿ, ಅವ್ರದ್ದಾಯ್ತು. It's between them. Who are you?
I'm also related to the.
You're only a niece. So therefore, till that case is decided before the assistant commissioner or deputy commissioner, whoever it is.
I mean, is that the vendor of the place has to go. According to she was supposed to go.
So it is between them. So who are?
I'm here because I am the cause of evolution. Here, but in that, who will not and release it. Just the temporary is not granted.
That's true. That's true. You're not a party in that suit. You're not interested in any of the other property. So let the injunction be granted except the temple portion. Yes. Because this injunction, that suit is filed by whom? Nagamma. So therefore, Nagamma is not a party here. So how is it going to bother you? Of course. The petition is filed by the plaintiff in OS number 430 of 2017 on the file of the additional civil judge in JMFC Beltangli, challenging an order dated 6/3/2020, by which an application filed by him for interim injunction was rejected. Or was vacated. Where an application filed by him, by which the ex parte or interim order of injunction granted was vacated. Next paragraph. Continue. So he has also challenged an order dated 4/4/2022 passed by the appellate court in MA 5/2020, by which the order of the trial court is confirmed. Next paragraph. The parties shall henceforth be referred to as they were arraigned before the trial court. Next paragraph. The suit in OS number 430 of 2017 was filed for perpetual injunction. Was filed for perpetual injunction in respect of the land bearing survey number. In respect to the land bearing survey number. Bearing survey number 35/23, 35/8, 35/3, 35/22, all situated in Bandaru village, Beltangli Taluk. Full stop. The plaintiff claimed that the aforesaid land was earlier owned and possessed by Monaya Gowda and was succeeded by his wife Srimati Nagamma, who sold the suit properties to the plaintiff in terms of a sale deed dated 27/6/2015. Full stop. He claimed that the defendants were utter strangers to the suit schedule properties. Therefore, but were interfering with his possession and therefore filed a suit for perpetual injunction against the defendants. So along with the plaint, an application was filed for interim injunction, restraining the defendants from interfering with the possession of the plaintiff. Full stop. The trial court granted an ex parte order of injunction. Full stop. The defendants entered appearance and contested the suit by filing the written statement. They contended that a temple existed on the land bearing survey number 35/8 in an area measuring 15 cents, and that the general public were managing the said temple by forming a committee to stop. They also claimed that Srimati Nagamma had handed over the possession of the land and the temple to the general public in the year 2007 itself. Full stop. They claimed that the public were worshipping the Kalkuda and Kallurti Devas, the temple, and that the general public had renovated the temple by collecting huge donations from the general public and the elected representatives. Stop. The defendants placed on record photographs of the temple, and claimed that the plaintiff was not in possession of the said temple and therefore could not restrain the defendants from performing religious rites in the temple. Full stop. Next paragraph. They also claimed that the vendor of the plaintiff had filed OS number 129/2017 for cancellation of the sale deed dated 27/6/19. What is suit number? 163/2022. Set aside the sale deed dated 27/6/2015 executed in favor of the plaintiff where there is an order of injunction. Is there an order of injunction? Where there is an order of interim injunction restraining the plaintiff from interfering with the possession of Srimati Nagamma. Please stop. In respect of survey number 35/3 and 35/20. Please stop. Next paragraph. I consider the submission made by the Learned Counsel. It is not in dispute that the suit properties were owned and possessed by Nonaya Gowda, which was later succeeded by his wife Srimati Nagamma, who sold it to the plaintiff in terms of the sale deed dated 27/6/2015. The sale deed bears a reference to a temple, and it is mentioned that the property sold included the temple. Full stop. An attempt made by the vendor of the plaintiff to set aside the sale deed by invoking the provisions of the Maintenance of Senior Citizens and Parents and Senior Citizens Act 2007, which was rejected, and thereafter, she has filed a suit in OS number 163 of 2022. Please stop. Notwithstanding the above, since the present suit is for injunction against the defendants who are in no way concerned to the suit property, the trial court ought to have considered the same in view of the sale deed executed in favor of the plaintiff. Full stop. It is not in dispute that the temple exists on the land bearing survey number 35/8. 35/8 in an area measuring 15 cents. Then tahsildar martad. In an area measuring 15 cents. The plaintiff also does not dispute the existence of the temple. Stop. In that view of the matter, the trial court could have restricted the order of interim injunction against the defendants in respect of all other properties except the temple in an area measuring 15 cents in survey number 35/8. Stop. Both the trial court and the first appellate court committed an error in rejecting the application for interim protection on the premise that a temple existed on one of the suit items and that the sale deed in favor of the plaintiff was challenged by her vendor in OS number 163 of 2022. Consequently, both the courts have committed an error in refusing to grant an interim injunction. Therefore, the same deserves to be interfered with. Consequently, the following order is passed. The writ petition is allowed in part. The defendants are restrained from interfering with the possession of the plaintiff in the suit properties except in an area measuring 15 cents in survey number 35/8. ಸಣ್ಣ ದೇವಸ್ಥಾನ ಹೋಗದ ರಸ್ತೆ ಬೇಕು, ಹೋಗಿದ ತಕ್ಷಣ ಅಲ್ಲಿ ನಿಂತ್ಕೊಳ್ಳೋ ಜಾಗ ಬೇಕು, ಕೆಲಸ ಮಾಡಕ್ಕೆ ಏನೋ ಬೇಕಲ್ವಲ್ಲ. ಆಯ್ತು. In an area measuring 15 cents in survey number 35/8. Stop. The plaintiff shall not disturb the devotees of the temple from entering and exiting into and from the temple or perform religious functions or ceremonies in the temple. Stop. This is, however, subject to the outcome of the suit in OS number 430 of 2017. This is, however, subject to the final result of OS number 430 of 2017. Stop. Yes. ಇದ್ರಲ್ಲಿ ಮಾತ್ರ ಅದರಲ್ಲಿನ ಎಕ್ಸ್ಪರ್ಟ್ ತಾನೆ. Don't argue for Nagamma. Why are you arguing for Nagamma? Let her come. Yes, Venkat Subbarao. Huh? Awaiting service of notice to R1 to R4. Yes. Who accepts? Do you accept notice R1 to R4? Yaru? Venkat Lakshmamma. Mr. Mr. Vivek? Mr. Vivek BR has entered appearance for the respondents 1 to 4. Office is directed to show the name of Mr. Vivek BR as the counsel for response 1 to 4. Yes, when do you want it? Really, name here, it's on. They are great good. Yavatu? 15 September, Mr. What is the urgency? What is the stage of the suit? Without getting over this, they cannot go on with the further evidence, isn't it? Yavatu date? Let it come on 15 September. Interim order is extended to the next day. Yes. Amendment and what, who has filed the application for amendment? Who is for partition? We filed the application stage of cross-examination PW1. You are not changing the relief. Okay, why is it rejected then? Okay. To notice, in addition, the learned counsel for the petition is granted to serve. The learned counsel who represented the respondents before the trial court. He takes the risk, madam. Why you want to impede all these people? They'll come in final decree. The partition suit, it is only the heirs, sharers who can be brought up, who can be proceeded against. You need not proceed against everybody who was purchased. Why should you proceed against them? Will they answer any of the issues in the suit? Can they come and give evidence? Whether you're a member of a family or not member of a family, can they come and give evidence? So why do you proceed against them? Waste of time. If he has gifted it to his daughter will get the share what the defendant number 1 will get. Alva. And she will come in the final decree proceedings and seek for allotment of the share of the defendant number 1 to her. Why you want to impede them? Further proceedings in OS number 198 of 2018 on the file of the so-and-so court is stayed till the next date of hearing. List on 15 September. Please pay the process today itself. That also is given the liberty. Huh? Yes, yes. And release it from part and let it go to court. Let it go before non madad beda. Varkul. Released from part. Office is granted to list this inspection before the appropriate bench having roster. ಎಲ್ಲೇ ಬಿಡಿ ಏನು ನನ್ನ ಮುಂದೆ ಯಾಕೆ ಬರ್ತದೆ? ಹಾ. Which court has tagged on? This court has tagged on. The request of the learned counsel for the petitions. ಯಾವ tag on ಆಗಿದೆ? If both of you are ready, you are ready now. Really there. Ready na, you hear it? Yes. Yes, Mr. G. Lakshmi Shroff. Huh? 2012 next ದಿನ ಇಟ್ಕೊಳ್ಳೋಣ. Non-filing of amended cost title by advocate for petitioner. Records ಬಂದಿದೆಯಂತೆ. The HCGP has made a submission on the last day that the records are received. Learned AG submits that he has secured the original file ಅಂತಿದೆ. ಯಾವತ್ತು ಹೇಳಿ? You please pick a date, old matter. At the request of the counsel for petitioner, this on Wednesday, Nadida, day after tomorrow. ರಜಾ ಇದೆಯಲ್ಲ, 31st ರಜಾ. ಯಾವ ಡೇಟ್ ಕೊಡಿ, ಹಳೆ ಮ್ಯಾಟ್ರ್ ಕೊಡಿ. 1st September. SR Sri Prasad. Yes. Mr. T.N. Raghupati. Mr. T.N. Raghupati. Yes, please. Huh? 14. Plain ta?
First one, one side share. Thereafter, commissioner was appointed by demarcating producer as demarcated. But thereafter, what the person filed a memo for dismissal of the proceedings.
Dismissal.
Dismissal. As not present.
Yes.
But the contesting respondent very good. Respondent number 10, she filed an objection. Telling to the legal representative of the head. Not to dismiss the Lord of the court dismisses the proceedings. Thereafter, we are challenging the dismissal of the proceedings by available to the next. Yeah, please dismiss. But thereafter, she filed the proceedings. This was not challenged.
Now challenging this order, other activities. We are taking 1 or 2,000 the election. But I find application and election G makes it one. Regarding maintaining the gates and from I-6.
Where is the decree? Decree over the out there share idea. Please wait. Please wait. Please wait. No, the petitioner was 22nd FDP. What's up? Usha is daughter of Chandrasekhar Naidu. The decree ಏನಂತ ಆಗಿದೆ? Defined 2 to 6 have also got 1/6 share each in the suit property.
That's why when the two is other than 25, why is that son? Why is between son and son? And one thing.
It could be Mr.
Whatever she has.
No. Question is, this final decree was not allowed. And you did not allow the final decree to come to a conclusion. Authority. Your vendor did not allow the final decree proceedings to conclude. ಅವರೇ ಮಾಡುದು ಕಮಿಷನರ್ ಸ್ಕೆಚ್ ಮಾಡಿದ ತಕ್ಷಣ ವಿಡ್ರಾ ಮಾಡಿ.
Objection was rejected. CRP was dismissed. Challenging order passed by.
CRP. No, just wait. CRP. You mean the CRP which is at page number 52? That is for objections to the memo filed for withdrawal. Final decree, final decree drawn agilla. Final decree draw agilla. Has she filed objections to the commissioner's report?
She has not filed objections to commissioner.
So if the final decree is not drawn, if it is not drawn, therefore there is no final decree at all.
Commissioner report is there.
It is of no use. It is of no use.
I difficultly back the subject. She says she is only what that is the petition filed.
ಅದು FDP ನಲ್ಲಿ ಡಿಸೈಡ್ ಆಗ್ತದೆ ಸೋಲೋ ಇಂತಿದಾರ ಮಕ್ಕಳಿದಾರ.
Again, false statement before.
You file an application to include the other legal heirs. If ಯಾರಿಂದ ಕೊಂಡ್ಕೊಂಡಿರೋದು.
Now the final is.
So why are you bothered? ಚಂದ್ರಶೇಖರ್ ನಾಯ್ಡು ಏನು ಹೋಗುತ್ತೆ ಅಂತ ನೀವು why are you bothered?
Overlap ಆಗುತ್ತೆ. Possession ಅಲ್ಲಿ ಯಾರು ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಮಾಡ್ತಾರೆ?
ಏನ್ ಮಾಡಕ್ಕೆ? You purchase it from 4 and 5, huh? It is Papai Naidu. Papai Naidu share. 4, 5 and 6. So therefore you have purchased Papai Naidu share. No, but where is the final decree? But why not? She is filing it for her share. ಅಂದ್ರೆ ನಿಮ್ ಫೈನಲ್ ಡಿಗ್ರಿ ಇದು ಫಸ್ಟ್ ಫೈನಲ್ ಡಿಗ್ರಿ ಕನ್ಕ್ಲೂಡ್ ಆಗಿದ್ರೆ ವಾಟ್ ಯು ಸೇ ಇಸ್ ರೈಟ್. ಫಸ್ಟ್ ಫೈನಲ್ ಡಿಗ್ರಿ ಕನ್ಕ್ಲೂಡ್ ಆಗ್ಲಿಲ್ವಲ್ಲ. ಚಂದ್ರಶೇಖರ್ ನಾಯ್ಡುದು ವಾಟ್ ಈಸ್ ದಿ ಶೇರ್ ಆಫ್ ಚಂದ್ರಶೇಖರ್ ನಾಯ್ಡು ದಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಕನ್ಕ್ಲೂಡ್. ಸ್ಕೆಚ್ ಅಲ್ಲಿ ಇದೆ. ಸ್ಕೆಚ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಎಕ್ಸೆಪ್ಟ್. ಆರ್ ಯು ಟ್ರೈಂಗ್ ಟು ಕನ್ಫ್ಯೂಸ್ ಮೀ ಔಟ್? ಮತ್ತೆ Now, you might face some inconvenience, can't help it. You purchased the property even before the final decree was drawn. Yen mada? That's a mistake. So now the application filed in FDP 1 of 2011 is rejected, huh?
My application is, later the second application.
Correct ಮಾಡಿದ್ರು.
Yes, it's nearly.
Settlement ಮಾಡ್ಕೊಳ್ಳಿಲ್ಲ ಅಂದ್ರೆ. This is the only way. Sir, this you should have done it. Then you, can't you make an assessment? Sir, who was it? Mr. T. N. Raghupati? Password ನೋಡ ಅವೇನೋ ಒಪ್ಪಿಲ್ಲ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ತಾರೆ ಪಾಸ್ವರ್ಡ್ ಎವಿ ಗಂಗಾಧರ್ ಪಾಸ್ವರ್ಡ್ ಎಂ ಶ್ರೀನಿವಾಸ ಪಾಸ್ವರ್ಡ್ ಸಂಜಯ್ ಎಚ್ ಶೇಟಿಯಾ ಏನ್ ಅಪ್ಲಿಕೇಶನ್ ಇದೆಲ್ಲ ಯಾವ ಹಿಂದೂಸ್ತಾನ್ ಕನ್ಸ್ಟ್ರಕ್ಷನ್ ಕಂಪನಿ OS 4446 is filed by Hindustan. So that suit is for what? ಎಲ್ಲಿಂದ ಫೈಲ್ ಆಗಲಿ? Why is it, what for what it is filed? It's for statement of particular claim. Defendant number 1 is not entitled to award the balance work to a third party. Same work. I on merit side, merit side. Actually, here is some application. Repetition ನಾನು ಹೇಳ್ತಿರೋದು. Oh, so this is an application filed under section 10 of the Code of Civil Procedure. ಬೇರೆ ಫೈಲ್ ಹೋಗಿದೆ ನೋಡಿ ನಿಮಗೆ. The impugned order is at annexure E under section 10. ಬೇರೆ ಕೋರ್ಟ್ ದಿನ ನೋಡ್ಕೊಂಡ್ ಬರ್ತಿದ್ರು ನೋಡಿ. To set aside the impugned order dated 11/9/2017. 11/9/2017 is an application filed under section 10. Good, good. ಬಾಂಬೆ ಸೂಟ್ ಇದೆ ಅದಕ್ಕೆ ಇದನ್ನ ಸ್ಟೇ ಮಾಡಿ ಅಂತ ಕೇಳ್ತಿದ್ದಾರೆ. Yes, Mr. Sanjay Sethia. Passport. Mr. Dhruv Kumar. Passport. Karva. Correct, he is not there. Either passover or adjournment. Correct, either passover or adjournment. You decide. Passover. Mr. Ravindra VS.
And I am for the petitioner. I am for the petitioner.
Passover alva 54. Passover.
At 57, man.
ಐವತ್ತು ಲಕ್ಷ ಎಟ್ಲಿವ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತ ಹೇಳಿದ್ವಿ. ಅಲ್ಲ ಏನೋ ಇಂಟ್ರೆಸ್ಟ್ ಬೇಡ, ಪ್ರಿನ್ಸಿಪಲ್ ಕ್ಲೋಸ್ ಮಾಡಿ. At the request of the counsel for petition and response, number 54. List on yavat. List on 7th. 7th September. Yes, VS Ravindra.
My lord, I am for the petitioner, my lord. My lord, now, my lord, what is happened, my lord, in the one issue of my lord has filed a suit for injunction. Where injunction against my lord, my father.
ಈಶ್ವರಪ್ಪ ಅಂದ್ರೆ ನಂಗೆ ಯಾರು ಅಂತ ಗೊತ್ತಿಲ್ಲ, ಹೇಳ್ಬೇಕಲ್ವಾ ಯಾರು?
ಅಲ್ಲ, ಈಶ್ವರಪ್ಪ, who is my lord the respond number 1 husband, respond number 2 and 3 father.
He has filed a suit for
permanent injunction against my lord the Narsimappa, that is my father.
Yes.
Petitioner father and husband.
ಏನಾಯ್ತು?
And now, my lord, what is the problem? The suit has been declared during 2012 itself.
Yes.
Thereafter, my lord, my father has filed a RA, my lord. RA is dismissed. Now, my lord, the execution petition has been filed, my lord, by the legal heirs of my lord, Ishwarappa, or against my father during 2013 itself. But while filing, my lord, the execution petition, my lord, one application has been filed seeking police help. In the said, my lord, the application affidavit has been sworn stating that during 2013 itself, my lord, the Narsimappa is, my lord, the making interfering with the social property. In spite of, my lord, there is a decree in their favor. My lord, the application along with, my lord, to filed for seeking police help during 2013 itself when the execution petition is filed. Now, after lapse of, my lord, 9 years, and now the court has passed an order, my lord, directing, please, please, my lord, I, my lord, with respect to passing of order for police help, is that annexed G, my lord, in page number 69. My lord, being, my lord, the petitioner, being the legal heirs of, my lord, the Narsimappa, who is a defendant before the trial court, my lord, in the execution petition, my lord, I have not been, my lord, brought as a party in the, my lord, the execution petition. My father is only, my lord, as a made as a party, not the judgment at all. But now, yes, my father is died on, my lord, 6/9/2019. Before passing of this order, after passing of this order. Now taking advantage of the passing of the order in execution petition, which has been closed during 21/1/2019
You
itself.
give an undertaking that you will not interfere with their possession.
Now the affidavit is sworn with respect to the act which has been done during 2013 by my father. Now I am not interfering. By considering this, I am regularly the police are calling upon to the police station. ಇವರು ಹಳೇದೇನೋ ಡಿಸ್ಪ್ಯೂಟ್ ಇಟ್ಕೊಂಡ್ಬಿಟ್ಟು ಇವಾಗ ಬಂದ್ಬಿಟ್ಟು ನಮ್ಮನ್ನ being a legal aid, he is want to enforce the execution petition
The
order.
legal aids given undertaking, let the legal aids given undertaking that you will not interfere with the possession of the plaintiff. Given undertaking.
Or before the police,
Before the police or before this court or.
because already execution petition has been closed.
Sir, there can be any number of execution petitions.
Please,
The permanent injunction decree, there can be any number of execution petitions. Even undertaking will not interfere with the possession. See, what is the fun in taking a decree if they can't execute it, mister?
With respect to while passing order, I should be given an opportunity to make my submission before the court before passing of this order. Because
No, the only submission that you can make is that you are not interfering.
Please,
because there is already a decree of injunction granted against you. So what is that you can say? You can only say that I am not interfering. If you say that before the court, that's the end of it. Given affidavit that you will not interfere.
Next week or 2 weeks, I will obtain the affidavit from the party.
Yes, sir. Next, learned counsel for the petitioner seeks time to secure instructions from the petitioner about filing of an affidavit undertaking not to interfere with the possession of the respondents in the suitable property.
But till such period, the interim order. Already the court has granted interim order.
Sir, there is a decree.
But I am not disputing that. I am not disputing that there is a decree.
Police, but if you are not interfere with their possession, they will not go to the police. Do you think going to the police is a happy thing? No.
That is
even undertaking.
I will file necessary affidavit before this court, but till such period, interim order.
Unconstituted petitioner seeks time to secure instructions from the petitioner about filing of an affidavit undertaking not to interfere with the position of the
Position of the plaintiff in this case.
Because it is not a judgment in drum, that is a judgment in personam. Whether he can enforce against the legal.
So why did you file an application to bring the legal representatives of the plaintiff in RA? We have
not filed, the RA has been filed by my father.
Why did you implicate the LRs of the plaintiff in that appeal?
In appeal,
the man is dead. So therefore the appeal is abated until close. LR's application, this is, you don't apply your mind at all.
Their legal representative has been brought on.
Why did you do it? This one, grateful. Not grateful. 8 September.
Till such period, the interim order. I will file abroad before this court.
If you are not interfering with their possession, why worry about the police? No. Any objection? Any objection? To the request of the counsel for petitioner and respondent list on it. The model is extended to the next set of code. Huh? 24. Process ಕಟ್ಟಬೇಕು ಕಟ್ಟಿ ಅದನ್ನು ಕಟ್ಟಿ
Court officer. Court officer. Court officer.
Number? Yeah, Rajendra K. Infectious ಆಗಿದೆ ಅಂತಾರೆ. ನೋಡೋಣ ಕರೆಯೋಣ. ನೆಕ್ಸ್ಟ್ ಯಾವ್ದು ಕರೀರಿ? ಕರೀರಿ ಯಾವ್ದು? Since the petitioner has already submitted its reply to the notice dated 20th of July 2015 impugned herein, this petition is allowed in part. The respondent number 1 and 2 shall consider the reply in the light of the observations made above and pass appropriate orders. While doing so, the response 1 and 2 shall ascertain whether the petition is running a retail shop or a retail shopping complex in the petition scheduled property and apply the zoning regulations as it stood prior to 11/12/2014 or 20th of March 2015. Until the same is considered, the respondents 1 and 2 shall not disturb the establishment of the petitioner. Which one? How is your name spelled? It's Hard copy ಕೊಡ್ರಿ. It is properly spelled as Sampath only. Yes, what is? Yeah, that is for legal 321 proceedings. ಅದನ್ನು ಕನ್ಸಿಡರ್ ಮಾಡಿದೆ. ಕರೀರಿ ಯಾವ್ದೊಂದು ಕರೀರಿ. ಹಾ But you say the suit is not maintainable.
There is no such condition. There is no such condition.
We're not on that. We're not on that. You said the suit is not maintainable. On facts, it is maintainable. Yes.
There is no such contention. There is no condition.
Mister, that is not the question. Now, what he says is that he has executed a power of attorney, but certain amounts were supposed to be paid to him. You conveyed the sites to various purchasers. You did not give the accounts to him. You did not pay the money that was supposed to be paid to the plaintiff. So therefore, he says that I wanted to cancel the power of attorney.
There is no such condition. As per the government system. Condition number 1 to 40. There are no such condition.
There is something else other than the power of attorney we could understand. Is there any other document other than the power of attorney? No, Mister, what I am trying to tell you is, if there was any other document under which you have paid the entire consideration, who is he? Is he related to you? Is he a blood relative? No. Why would he execute a power of attorney, giving all the powers to sell without giving any money? Have you paid the entire money as per the MOU? How?
Right, cash and others. That is the something that there is no dispute. With regard to the certain dates, these are concerned. I have negotiated not but I have taken 16 nights to do not maybe.
To get the suit disposed of, Mr. These are matters for settlement. No, sir. Not to alienate Putra the state, sorry. You might have invested, what can be done? So the purpose of the suit will be defeated if the properties are sold. Purpose of the suit will be defeated if the properties.
I cannot be a but these are crazy also.
Yes.
When it is acted upon, there is so far as voting is not concerned.
Please come to para 5. Go there. Plaint, page 185.
He acted the some portion
This, all right, Mr. Come. The defendant invoice number 19 of 2020 before the Principal Civil Judge and JMFC Nelmangla has filed this writ petition challenging an order dated 1/12/2020 by which the trial court granted an interim order of injunction restraining the defendant from alienating his mutual properties. He is also challenged, well, they have also challenged the order passed by the appellate court in MA 2/2021, by which the order of grant of interim injunction was confirmed. Next para. The suit invoice number 19/2020 was filed for a direction to the defendant to execute a deed of cancellation of the power of attorney dated 4/8/2014 and for perpetual injunction restraining the defendant from creating third-party right over the suit properties. Full stop. Along with the suit, an application was filed by the plaintiffs for interim injunction restraining the defendant from alienating or creating any third-party right in respect of the suit real properties. Next para. The plaintiffs claimed that they were the absolute owners of the property bearing survey number 34, measuring 3 acres, situated at Mallapura, Kasba Hubli, Nelmangla Taluk. Which was converted for non-agricultural residential use. Full stop. Out of the total sites formed in the proposed land, The site bearing numbers 1, 11, 13, 16, 19, 21, 22, 26, 27, 28, 35, 36, 41, 43, 44, 45, 46, 47, 48, 60, 61, and 62. Were the subject matter of general power of attorney dated 4/8/2014 in favor of the defendant. After the execution of the power of attorney, the defendant conveyed the sites to various purchasers and rendered accounts till the first week of December 2019, but later turned hostile. Full stop. They alleged that they had transacted in respect of certain other portions of the sites in favor of various purchasers, but failed to pay the consideration in respect of those sites. Full stop. Hence, the plaintiffs caused a notice to cancel the power of attorney, and since the defendant continued with his acts, the plaintiffs were forced to file the suit for the reliefs mentioned above. Stop. The defendant, on the other hand, contested the suit and claimed that based on the power of attorney, he had executed various sale deeds and that he was prompt in payment of the consideration to the plaintiffs. And therefore, the plaintiffs were not justified in seeking for cancellation of the power of attorney. Based on these rival contentions, the trial court considered the application, filed for interim injunction and granted the same, and restrained the defendant from alienating or encumbering the suit's real properties. Stop. An appeal preferred by the defendant before the appellate court in MA number so and so was also rejected. Being agreed by the same, the present petition is filed. The learned counsel for the petitioner submitted that in addition to the power of attorney executed in favor of the defendant, a memorandum of understanding was executed on 8/8/2018, 8/8/2018, in terms of which he had paid the entire consideration to the plaintiffs, and therefore they could not have sought for cancellation of the power of attorney. He further submitted that he has entered into, the defendant has entered into various agreements of sale based on the power of attorney, and the order granting injunction has come in the way of concluding the said transaction. Stop. As per a perusal of the plaint discloses that the plaintiffs had made a categorical statement to the defendant, who was supposed to render accounts, had failed to do so, and therefore, they had issued a notice of termination of the tenant of the power of attorney. Stop. Since the issue was, since the suit involved a tribal issue regarding the lawful execution of regarding the extent to which the power of attorney was executed, and also whether the power of attorney rendered true and correct accounts to the plaintiffs, the trial court was justified in granting an interim injunction, which was to protect the status quo of the property. In that way of the matter, this court does not find any reason to interfere with the Order passed to the trial court and the appellate court. Hence, this is petition lacks. ನೆಲಮಂಗಲ ಕೋರ್ಟ್ ಇದು ಮತ್ತೆ 3,000 ಸೂಟ್ ಇದೆ ನೆಲಮಂಗಲ ಕೋರ್ಟ್ ಫಾರ್ ಇನ್ಫಾರ್ಮೇಶನ್. There are 3,000 and odd suits. One judge is handling 2 court, what you call pendency. Next. So what is the suit for? Declaration.
This was the class. And I did very much that I now, parents start and going on. One more second, I want to come on board. They is not that. They are the grandchildren of the very sick person who was doing.
Ramegowda. Grandchildren of Ramegowda.
They are from 9 to 12. Why not submit any document which they have read? The first document that close, I will be in the name of the matter. And first, the objection was to the taking of the government. That then
So this Chikkatimaya is the son of Ramegowda from Bairamma. Chikkatimaya, is he the son of Ramegowda from his first wife or second wife? Bairamma. One was the mother of the petitioner.
One more was the son of the Then Chikkatimaya passes the issue.
The persons who want to now come on record are the children from the second wife, Chikkamma. Let the court will decide whether they are entitled to or not.
Just see this. These are the list of documents that's what we read. I cannot use it. These are good documents. But we are not looking at it.
Just because they are implemented, will they get any right?
This entire case is running on the basis of someone creates a purpose saying that I am not going to. Then we don't do what we are going to do. Actually, you know, the say well,
Suppose if this impleading applicants are the children from the second wife. If that is a fact. Then are they not interested? Suppose if after trial, if it is found that they are indeed the children of Ramagowda from the second wife.
But it's not that. But the entire trial was started because because the mother was stating that he was great grandson to Ramagowda. And that I am not aware of it. Now, the students and state represent the almost very part. One more thing is created by the same people who produce. And this is very much problem very one more is but the legal action of Ramagowda can be decided with legal judge.
So tomorrow, if there is a settlement between the plaintiffs and the defendant. No.
Yes, because my even this.
Right, collusion could be in various ways, Mr. Right, collusion could be in various ways.
And there not have an opportunity to look at it. When is it not? When is it? That is why you can do a lot of research. When is it not? 27.
Second line, first line, now proposed defendants 9 to 12.
I will do the GP, and they have shown Chitrama. He doesn't make a problem, and Vedama is taking a problem. And this was not even deadline. He has been published at the time of repair. He has finished everything right. And at the time of repair, not yet published. Then not. But the plaintiffs are claiming their father, this is a problem when you work. We are leading to Vedama directly to the and if you watch to see, we are giving our father super rounds. These are findings which are obfuscated by very weak. But the plaintiffs are taking to the father super rounds, advocating Sir Vedama and Ramagowda. No, and other Nasa death certificate of Hanuman shown the husband of Ramagowda. Death certificate, Ramagowda is required. Death certificate, part of the news also know. Patient who has tried objections to again well. In the statement of objection certificate, it's a matter of right whether Ramagowda has got to wait. Meaning there is an plaintiff is also asking denying a dispute to the related and also proposed it Ramagowda. For elder succession. Advocated Ramagowda, who was participating Ramagowda has to wait. Advocated Ramagowda has followed. Property is recommended inherited by the father of the therefore his father Ramagowda. Again, through his mother Vedama. Let's say they are issued obfuscated.
Correct, but ultimately, by just impleading persons, will they get any share?
This is again and again, parties are to settle to begin it.
Yes.
Again and again, not parties are to begin it. All I'm saying is not, we have not done the proper and we do not have a chance to rebut it.
Yes.
But given an opportunity, I can say, I can point out who are there. Because when I can find out some form of a motive. And for these things.
Those things, Mr. It's only at the time of trial.
These cases, or traditionally, if there can be any employee who are ST, that is late, the Karnataka member is there. In such cases, not employee is suspect.
Yes.
That has not been taken. That is why not our only concern was.
What is 37A?
It's a
37A of?
Yes. It's a Karnataka member.
Good. Yes.
There is a provision for inquiry in this.
It's only order 37A. How is 37A applicable here? Right. Rather than. What are the documents that the trial court has looked into?
And affidavit will also keep it.
Really raise the application.
61. And in page 61, para 5. The document number 4 is what found here. The GP of the family. In the month under the dated 7 pages. And they are not produced it by something to these applications. It was not in the court record.
So notice just. Issue notice. And the learned counsel for the. New Year. 9 to 12. Mr. Pawan. Mr. Pawan M.N. has entered appearance for the respondent number 9 to 12, who are the impleading applicants before the trial court. Full stop. Hence, notice to the contesting respondents is served. Notice to response 1 to 8 is dispensed. This here, Ediano, what is that? 10 days salary. What is your, how do you demonstrate your relationship with Ramegoda? Very G3L agala. Nadeli Talido. From who has issued that document? On what basis? A ration card produce not the you should have done that. You should have done this. You should have produced a ration card. Produce model. Trial court produce model. When will you argue? Huh? Within 5 days, you'll argue. Date नहीं told. 28th. रजा ही दिया लाओ. 29th August. Yes. और ये documents ಇದೆಲ್ಲ ತಗೊಂಬನ್ನಿ. Why will it be struck off? Can the plaintiff be struck off? Why do you make this loose statements? I don't know. Can the plaintiff be struck off if you don't implead them? No. Yes, next. ಏನದು? Counterclaim alwa? Issues are not framed regarding the counterclaim. Whether issues are framed regarding the counterclaim. ಇದು 2020 ಆಯ್ತು. When was the counterclaim raised? When was the written statement filed?
I find the written statement with the court claim in 2015. On 15/3/2015, I filed the written statement with the court claim.
Where's your counterclaim?
Page
35.
29. Local page 35.
That will direct the trial court to frame issues. Will direct the trial court to frame issues based on the counterclaim and the written statement.
And I got lots of attention to what we do this week. Along the, it is the duty of the defendant and the right to file the next statement. And let's do that. The trial court has got the right to pronounce the statement. I when I brought this to know with the other trial court, then only they file the application. So I this is also the please for that. All we have to do is just need.
Something similar to Order 8 Rule 10. Something similar to Order 8 Rule 10. So therefore, there is no automatic judgment.
May.
May doesn't mean.
I should not be on 600 of the it is a trial. I know the issue.
I think we'll increase the cost, sir. We'll impose some compensatory cost upon the plaintiff. No, we'll impose some compensatory cost on the plaintiff for filing a delayed count.
Whatever the prosecution want to do, you can take a different angle. I get the detail because I depend on it.
Correct. That you reserve before the trial court, sir. The prayatna patre agutto illo amel tirmana madre. The High Court will always be there. Correct. No. Issues are not framed on the counterclaim according to you. There is a question of leading evidence on the.
Not at this stage, I would have made the submission with the appointed written statement. Because they are not read the written statement, and I would like to request the trial court to facilitate it. In accordance with law, that's what I have done. It's not necessary for me to file the application for legal issues on what is meant. According to law and law, I am entitled to the
Yes, yes. So these are all procedural laws.
the procedural law does not have the lapse of one or two.
Correct.
There are lots of so many procedures. And we are not sitting at the very tree. These procedures are got to be followed.
Yes.
Because the date will definitely exist. So it becomes very difficult because the application dependency one to one. After the dependency, all we have to run permission. And
I
the
think-
maximum money to begin to be clear.
Maybe you will also come someday thinking that this is a banyan tree. You will also come someday.
Not this is the legal.
No, don't make this,
Legal divan.
don't make these hard-hitting statements.
Yeah, yeah.
The moment you say banyan tree, ಅಲ್ಲಲ್ಲ ನೀವು ಅರಳಿಕಟ್ಟೆ ಅಂತ ಹೇಳಿದ್ರಿ ಕನ್ನಡದಲ್ಲಿ ಹೇಳ್ರಿ ಅವ್ರಿಗೆ ನನ್ ಕೂತ್ ಕಂಟ್ಲು ನನ್ ಕೂತು ನೀವು ಅರಳಿಕಟ್ಟೆ ಅಂತ ಅಂದ್ರಿ ಸರ್ ಫೇರ್ ಎನಫ್ ಫೇರ್ ಎನಫ್ ಫೇರ್ ಎನಫ್ procedural lapse cannot be allowed to overtake substantive rights. Substantive rights cannot be overridden. ಯಾವುದು?
If I got a substantive right, in the law says that, and moreover, they are quite the application for convention and period, of consent of period. And whenever the right is a good, it is substantial right in my favor. That also has to be considered.
Yes. Anything else? Wonderful. The defendant in OS number 8960 of 2014. Defendant number, defendants in OS number 8960 of 2014 on the file of the so-and-so court has filed this petition challenging an order dated so-and-so passed therein by which the court granted permission to the plaintiff to file a written statement to the counterclaim raised by the defendants. Next para. The part is so-and-so. Number 3. Suit in OS number 8960 of 2014 was filed for partition and separate possession of the Schedule A and B properties, and to hold that the sale deed dated 16 to 1995 executed in favor of the defendants 4 and 5 and the gift deed dated 23/9/2014 are not binding upon the share of the plaintiff. They also sought for a declaration that the will dated 5/12/1986 and 13/5/1994 created by the 1994 were concocted, forced, and did not bind the interest of the plaintiff. Full stop. The defendants 1 to 3 contested the suit and raised a counterclaim contending that the plaintiff's husband was constructing the house where they were residing. Full stop. At that time, the property described in the written statement, which lay adjacent to the house of the plaintiff, was put up for sale. Full stop. The plaintiff and her husband negotiated for the purchase of the said property and paid advance sale consideration. Full stop. However, the plaintiff's husband could not raise money for paying the remaining consideration and hence turned towards the defendants for resistance. Full stop. The second and third defendant agreed to the proposal of the plaintiff that the plaintiff and her husband would contribute 1/3 of the sale consideration, while the second and third defendants would contribute 1/3 of the sale consideration each. And the said property would be the joint property of the plaintiff, second and third defendant in equal ratio. The said property comprised of 3 residential units, and consequently 1 unit fell to each of the plaintiff, fell to the plaintiff, defendants 2 and 3. Later, they entered into an agreement in terms of which, second and third defendant took full responsibility for construction of a new residential building on the said property comprising of 3 units. So after the construction was done, the same were let out to tenants. To stop. The plaintiff pleaded with the defendant, defendant number 2 and 3, that in view of her frequent financial condition, she would take the rent in respect of all the 3 units for a few years until her financial position stabilized. Full stop. They allege that whenever second and third defendants broached the subject of apportioning the rent, she went on postponing on one or the other grounds. The defendants 2 and 3 claim that they were the joint owners of the written statement property, and therefore they were entitled to an undivided interest therein. Their demand for partitioning the said property was not considered by the plaintiff. Therefore, the defendants 2 and 3 sought for a counterclaim to partition the written statement suit property, written statement scheduled property. And for an inquiry into mean profits. Full stop. Next paragraph. Based on these contentions, the trial court framed issues. Curiously, the trial court did not frame any issue regarding the counterclaim raised by the defendants 2 and 3. Be that as it may, long after the case proceeded for cross-examination, cross-examination of cross-examination of PW1, an application was filed by the plaintiff to file a belated written statement to the counterclaim. Full stop. The trial court considered the application and allowed it in terms of the order which is impugned in this writ petition. Next paragraph. The learned counsel for the defendants submit that the plaintiff was required to file a written statement within the time allowed under Order 8 of the Code of Civil Procedure and could not have slept over for nearly 6 years for filing the written statement to the counterclaim. We further submitted that when the defendants insisted the trial court to pass a decree, since there is no written statement to the counterclaim in view of Order 8 Rule 6C, at that stage, the plaintiff chose to file an application seeking permission of the trial court to file a written statement to the counterclaim. Full stop. The learned counsel submitted that the defendants 2 and 3 were entitled for a decree of their counterclaim due to the default of the plaintiff, which in itself was substantive in nature, and therefore, the trial court could not have liberally construed the delay, though there was no proper and sufficient explanation for the same. We'll stop. Next paragraph. The suit was for partition separate possession of the plaintiff's share in the suit's real property. The defendants raised a counterclaim in respect of a property which was not the subject matter of the suit, but was a separate suit which was allegedly purchased by the plaintiff and defendants 2 and 3. Full stop. Therefore, to contend that the defendants 2 and 3 had an indefeasible right for a decree to be passed in their favor due to the default on the part of the plaintiff in filing a counterclaim, is unjustified, as the defendants 2 and 3 were bound to establish various questions of fact, such as the contribution made by them for the purchase of the written statement scheduled property, and whether that the defendants 2 and 3 joined in the construction of the building or the written statement scheduled property. Full stop. No doubt, the plaintiff has been lethargic in not filing the written statement within time. However, procedural law. However, non-compliance of a procedural law cannot override a substantive right and therefore, substantive right. Full stop. In the present case, the suit was still at the infant stage where the PW1 was yet to be cross-examined. Full stop. Therefore, the trial court was justified in allowing the plaintiff to file written statement to the counterclaim raised by the defendants 2 and 3. The trial court may, however, while doing so, ought to have compensated the defendants for the loss of time in pursuing the suit. Full stop. Means pursuing the suit. Full stop. Full stop. Therefore, though the order passed by the trial court is unexceptionable, but still, having regard to the conduct of the plaintiff in sleeping over his rights for over 6.5 years, this court considers it appropriate to direct the trial court to impose cost of a sum of rupees 5,000 payable by the plaintiff to the defendants 2 and 3 on the next date of hearing. The writ petition stands disposed of on the above Observe. The above terms. We have allowed the objections to be filed to the counterclaim in the appeal, in second appeal. Yen madakagala. Yes. Very innocuous order.
Provide some property. Not really. And others can do that. Most of the size they are not.
But what is that she is asking for? She is only asking for not to alienate the properties. ಯಾಕೆ ಮಾಡಕ್ಕಾಗಲ್ಲ? ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ? ಅಲ್ಲ ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ ಅಂದ್ರೆ ಮನೆ ಕಟ್ಕೋಬೇಡಿ ಅಂತ ಯಾರು ಹೇಳಿದ್ದಾರೆ? ಮನೆ ಏನ್ ಮಾಡ್ಬೇಕು ಹೇಳಿ? Please suggest a solution for this. No, how can that be done? No, how can that be done? Can you say that ಆಯ್ತು ನೀವು ಇದ್ರಲ್ಲಿ ಮಾತ್ರ ತಗೊಳ್ಳಿ ಅದ್ರಲ್ಲಿ ತಗೋಬೇಡಿ ಹೇಳಕ್ಕಾಗುತ್ತೆ? Please work out your remedy before the civil court. ಅಲ್ಲೇ ಹೋಗಿ ಹೇಳಿ. Correct. Civil court ಅಲ್ಲಿ same. You make an offer to the civil court saying that we will protect the interest of the plaintiff in ABCD properties. We will not alienate. Athara ಏನು ಕೊಡಿ ಒಂದು ಆಫರ್ ಕೊಡಿ. So therefore ಇಲ್ಲಿ ಹೆಂಗ್ ಒಪ್ಕೋತಾರೆ? ಯಾರಿಗೆ? Let this suit ಎಷ್ಟನೇ ಇದು? That cannot. Let the case be decided. Correct, but ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಹೇಳಿ? ಸರ್ ಕೋರ್ಟ್ ಇರೋದು ಬರೋದಕ್ಕೆ. For people to come. ಅದು ನೋಡಿ ಎಷ್ಟು ಜನ ಇದ್ರು? 9-10. Again 1/6 share ಹೋಗುತ್ತಾ? ಆಯ್ತು 1/6 ಶೇರ್ ಬರ್ಬೇಕು ರಾಮಸ್ವಾಮಿಗೆ. ಅವ್ರು ಕೇಳಿರ್ಬೋದು ಅಲ್ಟಿಮೇಟ್ಲಿ ಎಷ್ಟು ಬರುತ್ತೆ ಹಿಂಗೆ. Avalappa is dead. Achamma is dead. ತಂದೆ ತಾಯಿ ಇಬ್ರು ತೀರೋಗಿದ್ದಾರೆ. There are 6 children. ಆಯ್ತು ಒಬ್ರು ಮಾಡಿ 1/7 ಆಯ್ತಲ್ಲ. Let you please face the trial. ಏನು ಮಾಡಕ್ಕಾಗಲ್ಲ ಸರ್. ಆಸ್ತಿ ಇದ್ಮೇಲೆ ನೆಗಡಿ ಇದ್ದಿದ್ದೆ ಏನ್ ಮಾಡಕ್ ಮೂಗಿರೋವರೆಗೂ ನೆಗಡಿ ಇದ್ದಿದ್ದೆ ಆಸ್ತಿ ಇರೋವರೆಗೂ ಲಿಟಿಗೇಷನ್ ಇದ್ದಿದ್ದೆ ಏನ್ ಮಾಡಕ್ please make an application, then we'll consider later. This is an appeal filed by the defendants. 1, 2, 3, 4, 5. 1, 2, 3, 4, and the LRs of defendant number 5. Challenging an order passed by the trial court, granting an interim injunction restraining alienation of the suit properties. Next para. The suit invoice number 2 of 2019 is filed for partition and separate possession. Partition, separate possession of the joint family as well as the ancestral property. The petitioner, the plaintiff has also sought for a declaration. The partition deed dated 25/11/2016 is illegal, null and void, and not binding on the plaintiff, and for consequential injunction. Stop. The plaintiff claimed that the suit's properties were owned and possessed by our grandfather. Plaintiff claims that her grandfather was the proprietor of a joint family and that she's the was the proprietors of a joint family, and that the defendants 1 and 2 were the children of the brother of, were the children of the uncle of the plaintiff. Please stop. We claim that all the suit properties were the properties that belong to the family. Some of which were acquired by her grandfather, while others were purchased in the names of the children of her uncles. Please stop. She alleged that the defendants had concocted a partition deed in respect of all the suit properties, and alleged that that document was brought about behind the back of the plaintiff. Full stop. She claimed that one of her aunts was not included in the partition deed, and certain other joint family properties were also not included. She alleged that her signature was obtained on the partition deed by fraud, coercion, misrepresentation, undue influence, etc. Hence, she sought for a general partition of all the suit properties, and also to declare that the registered that the partition deed dated 25/11/2016 was illegal. Full stop. Along with the suit, she filed an application for interim injunction restraining the defendants from alienating the suit properties. The defendants contested the suit and claimed that the partition effected in terms of the deed dated 25/11/2016 was equitable and was with the consent, notice, and knowledge of the plaintiff, and therefore, the suit for partition was not maintainable. Next para. Having regard to the contentions urged by the parties, the trial court held that there was a tribal case made out by the plaintiff and hence passed an order of injunction restraining the defendants from alienating the suit's real properties. To stop an appeal preferred by the defendants before the appellate court was rejected and the order of interim injunction granted by the trial court was confirmed. Being agreed by the said order, the defendants have filed this petition. Next, the learned senior counsel representing the defendants submitted that reopening a partition, submitted that granting an order of injunction would keep on hold a partition deed that is lawfully entered into between the parties. To stop, he submitted that granting an order of injunction restraining the alienation of all the suit properties would be deleterious to the interest of all the defendants in the suit, inasmuch as the plaintiff is entitled to half of 1/8 share in the suit's real properties, for which all the properties need not be brought under the did not be affected by the order of injunction granted. Full stop. Next para. The consideration for grant of interim injunction. The principles for the consideration for the purpose of grant of temporary injunction is overstated and does not require repetition. Full stop. Be that as it may, if the trial court has found from the material on record that the plaintiff had made out a tribal case, it also had to maintain the status quo of the suit's real properties. Full stop. One way of maintaining the status quo is to grant an order of injunction restraining the defendant from alienating or encumbering the suit's real properties. Full stop. This will not in any way come in the way of the parties enjoying the properties as per the partition deed set up by them. Full stop. Therefore, the order of interim injunction granted by the trial court is absolutely innocuous and does not affect the right of the parties, but is only to maintain status quo of the properties in question and to avoid multiplicity of proceedings. There is no error committed by the trial court warranted by this court, hence this petition lacks merit and justice. Counsel for the petitioner submits that he has paid the process to issue notice to R1, office that is directed to check, verify and proceed. There is no representation for the petitioner. 2 weeks' time is granted as a last chance to pay the process in respect to issue notice to respondents 1 and 2. Nadidira? A process kodi. Ivatte kodi. Counsel for the petitioner is granted 1 week time to pay the process to issue notice to response 1 to 3. Office is that list this petition along with WP number 15639 of 2020. There are advocate and serve model and the bandidella. We put back an acknowledgement. Sudarshan. ಯಾಕೆ ನೀವು 9 ವರ್ಷ ಮಾಡಿ 90 ವರ್ಷ ಮಾಡಿ ಸರ್ ಹಂಗಂದಾಗ ಬಿಸಾಕ್ತಾನೆ. Should you not throw the NOC on his face? ಆಯ್ತಪ್ಪ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಕೇಳು. Sir, are you trying to justify? Are you trying to justify? No, are you trying to justify yourself? Give the NOC now. ಕುಡಿಯೋದು ವಕಾಲತ್ತು ಕೊಡೋದಿಲ್ವಾ? ಆಯ್ತು ಬರ್ಕೊಳ್ಳಿ. ಆಯ್ತು ಅದು ನಿಮಗ್ ಬಿಟ್ಟಿದ್ದು. ಅದೇನೇನು ನೀವು ಮಾತಾಡ್ಕೊಂಡಿದ್ರು ಅದು ಗೊತ್ತಿಲ್ಲ. ಏನು ಮಾತಾಡಿದ್ರೆ ಅದ್ ನಿಮ್ ಮನೆ ಬರೋದು. Mister, whatever agreement that you have entered into with him, you please enforce it otherwise. If somebody comes and asks for the no objection, first thing that a lawyer should do is throw the NOC. That is the first thing. Mister, are you willing to give the NOC or not? ಕೊಡೋದಿಲ್ವಾ? ಬರ್ಕೊಳ್ಳಿ. How many years of practice you have put in? 15 ವರ್ಷ. ಇದೊಂದು ಕೇಸ್ ಬಿಟ್ಟು ಬೇರೆ ಇಲ್ವಾ ನಿಮ್ಗೆ? ಬರ್ಕೊಳ್ಳಿ. ಕೊಡಿ, ಅಡ್ವೊಕೇಟ್ಸ್ ಆಕ್ಟ್ ಕೊಡಿ. ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ದು ಒಂದು ಆಪರ್ಚುನಿಟಿ ಕೊಡಕ್ಕೆ ನಿಮ್ಗೆ. ನೀವು ಕೆಲಸ ಮಾಡೋದಲ್ಲಪ್ಪ, ಕೆಲಸ ಮಾಡಿದ್ ನೀವು ಫೀಸ್ ಇಸ್ಕೋಬೇಕು. ನೀವು ಕೆಲಸ ಮಾಡಿದ್ ನೀವು ಫೀಸ್ ಇಸ್ಕೋಬೇಕು. ವೈ ಆರ್ ಯು ಹೋಲ್ಡಿಂಗ್ ಅ ಪಾರ್ಟಿ? ವೈ ಆರ್ ಯು ಟೆಲಿಂಗ್ ಹಿಮ್ ದಟ್ ಐ ವಿಲ್ ನಾಟ್ ಗಿವ್ ದ ನೋ ಅಬ್ಜೆಕ್ಷನ್? It is his case, not your case. It is his case, mister. Who are you to hold it up? Evidence check ಮಾಡಿಲ್ಲ ಅವ್ರದ್ದು. So therefore, should you not give the NOC? Mister, should you not give the NOC when he is not cooperating with you? Should you not give the NOC? ಕೊಡ್ತೀರಾ ಇಲ್ಲಪ್ಪ? I am giving an opportunity. Great. Sir, please don't ಆಗಲಕಾಯಿ ಬೇವಿಕಾಯಿ ಸಾಕ್ಷಿ ತರ ಇರಬೇಡಿ. ಲಾಯರ್ಸ್ ಹೆಂಗಿರ್ಬೇಕು ಅಂತ ಕೇಳಿ. ಹಿಂದ್ಗಡೆ ಸೀನಿಯರ್ ಒಬ್ರು ಕೂತಿದ್ದಾರೆ, ಅವ್ರು ಕೇಳಿ. ಲಾಯರ್ಸ್ ಹೆಂಗಿರ್ಬೇಕು ಅಂತ ಸ್ವಲ್ಪ ತಿಳ್ಕೊಳ್ಳಿ. ಇಂಥವ್ರ ಮುಂದೆ ಸಣ್ಣವರಾಗೋದು ಬೇಡ ನಾವು. ಇಂಥವ್ರ ಮುಂದೆ ಸಣ್ಣವರಾಗೋದು ಬೇಡ ನಾವು. If a client comes and expresses no confidence in you, the first thing you should do is throw away the papers. ಅವ್ನು ದುಡ್ಡು ಕೊಡ್ತಾನೋ ಬಿಡ್ತಾನೋ, ನೀವು ಮಾನ ಮರ್ಯಾದೆ ಅನ್ನೋದು ಇಲ್ವಾ ನಿಮಗೆ? ಇಲ್ಲಲ್ವಾ ನಿಮ್ಗೆ? ಯಾರೋ ಬಂದು ಅವನು ತೂಚಿ ಮಿಸ್ಟರ್, ಒಂದು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬಂದು ಒಬ್ಬ ಕ್ಲೈಂಟ್ ಬಂದು ಫೈಲ್ ನಂಗೆ ವಾಪಸ್ ಕೊಡ್ತಿಲ್ಲ ಅಂದ್ರೆ ಇಸ್ ಇಟ್ ನಾಟ್ ಎ ಶೇಮ್ಫುಲ್ ಥಿಂಗ್? ಆಯ್ತು, ಫೀಸ್ ಎಷ್ಟು ಅಂತ ಮಾತಾಡಿದ್ದೀರಾ? ಯಾಕೆ ತಗೊಂಡ್ರಿ ಫೈಲ್? ಯಾಕೆ ತಗೊಂಡ್ರಿ ಫೈಲ್ ನೀವು? ವೈ ಡಿಡ್ ಯು ಟೇಕ್ ದ ವಕಾಲತ್ ಇನ್ ದ ಫಸ್ಟ್ ಇನ್ಸ್ಟೆನ್ಸ್? ಫಸ್ಟ್ NOC ಕೊಡಿ. NOC ಕೊಡಿ ಫಸ್ಟ್. ಕೋರ್ಟ್ ಅಲ್ಲೆಲ್ಲ ಡೋಂಟ್ ಲೂಸ್ ಯುವರ್ ಇಮೇಜ್ ಇನ್ ದ ಕೋರ್ಟ್. ಡೋಂಟ್ ಲೂಸ್ ಯುವರ್ ಇಮೇಜ್ ಇನ್ ದ ಕೋರ್ಟ್ ಮಿಸ್ಟರ್. 15 ವರ್ಷ ಪ್ರಾಕ್ಟೀಸ್. ಇದರಿಂದ ಒಬ್ಬಂದೇ ಕೇಸ್ ಇರೋದು ನಿಮ್ಮ ಹತ್ರ. Yes. What do you want to do? ಕೊಡಿ ಇವಾಗ. ಹತ್ತಾರು ಜನ ವಕೀಲರು ಕೂತಿರ್ತಾರೆ. ಅಲ್ಲಪ್ಪ ಹೇಳ್ತಿರೋ ಸ್ವಲ್ಪ ಶುಡ್ Nagbhushan sir, why don't you counsel people like youngsters like this? ಸ್ವಲ್ಪ ಏನೋ ಬುದ್ಧಿ ಹೇಳಿ ಕೇಳಂಗಿದ್ರೆ. ಕೊಡಿ ಇವಾಗ ತರಿಸ್ರಿ ಒಂದು ಒಕ್ಕಲು ತರಿಸ್ರಿ ಅಲ್ಲ ಸೊಸೈಟಿ ಕಳಿಸ್ಬಿಟ್ಟು ಮುಂಜಾನೆ sir, never do this. ಕೊಡಿ ಅದು ಕೊಡಿ ಏನ್ ಮಾಡ್ಕೊಡಿ ನೋಡಿ ಕರೆಕ್ಟ್ ಆಗಿದೆ ನೋಡ್ಕೊಳ್ಳಿ. As your client signed it. ಬರ್ಕೊಳ್ಳಿ. ನಿಮ್ಗೆ ಏನೋ ಇದು ಸಣ್ಣದಾಗಿ ಕಾಣ್ಬೋದು ನಿಮಗೆ. ಒಂದ್ಸತಿ ಏನಾದ್ರು ಹೆಚ್ಚು ಕಡಿಮೆ ಆಯ್ತು ಅಂತ you have to face adverse consequences. Please have that in your mind. ನೀವೇನ್ ನಿಮ್ನೇನ್ ಕಂಟ್ರೋಲ್ ಮಾಡಕ್ ಯಾರು ಇಲ್ಲ ಅಂತ ಅನ್ಕೋಬೇಡಿ ದಯವಿಟ್ಟು. Once you get into that grind, ಮುಗೀತದ ನಿಮ್ ಕತೆ. Mister, you should be clear when you take up the brief. ಕೇಸ್ ತಗೋವಾಗ ಏನ್ ಕೊಡ್ಬೇಕು ಏನ್ ಬಿಡ್ಬೇಕು ನೀವು ಕ್ಲಾರಿಟಿ ಇರ್ಬೇಕು. ಬರ್ಕೊಳ್ಳಿ. Courts are meant for litigants. They are all beneficiaries. Please understand that. Courts ಇರೋದು ಬರೀ litigants ಮಾತ್ರ, not to anybody else. We are all beneficiaries from the litigants. Court ಇಲ್ಲದೆ ನೀವೆಲ್ಲ litigant ಬರ್ದ್ರೆ ನೀವೆಲ್ಲ ಇರ್ತಿದ್ರಿ. What you would have been, mister? The court ಬಂದು ಲಾಯರ್ ಆಗಿ ಕೇಸ್ ನಡ್ಸಕ್ ಆಗ್ತಿತ್ತು, ಜನ ಬರ್ದೈತೆ. Courts are meant for the litigants, not for you and me. The petitioner was the defendant number 4 in OS number 819 of 2013. Was challenged an order dated 7/6/2022 passed therein by which an affidavit filed by him seeking leave of the court to engage another counsel without obtaining no objection from his previous counsel was rejected. Next para. The defendant number 4 who had engaged an advocate, chose to engage another advocate who filed his wakalat before the trial court. Full stop. The counsel who represented the defendant number 4 earlier also filed an affidavit stating that he had filed the written statement on the instructions of the defendant number 4, and he was appearing and he was defending the suit since the year 2013. However, the defendant number 4 had not paid his professional fee. Nonetheless, he continued to appear and represent the defendant number 4. With the hope that he would pay the professional fee. To stop. He declared that if the respondent number 4 withdrew the allegations made against him in the affidavit, he would have no objection for the defendant number 4 to engage any other counsel. The trial court, after considering the affidavit filed by the defendant number 4 as well as the counsel on record, rejected the wakalat filed by the defendant number 4 without obtaining the no objection from the earlier advocate. Being agreed by the said order, the defendant number 4 has filed this petition. Next, learned counsel for the defendant number 4 submitted that the counsel for the defendant number 4 did not examine the defendant number 4, even though the case was set down for the evidence of the defendants. She submitted that despite visiting the counsel several times, he did not issue the no objection, and therefore the defendant number 4 was forced to file an affidavit before the trial court seeking its leave to engage in new counsel. Next part. The case is listed for preliminary hearing, the counsel for the defendant number 4, Mr. Sudarshan, what's your full name? R. Sudarshan. Mr. R. Sudarshan appeared before the court and gave his no objection to the defendant number 4. Since the purpose of the petition is served, no further orders need to be passed. The defendant number 4 is at liberty to engage any other advocate of his choice and take appropriate proceedings in the suit. Yes. The petition stands disposed of on the vote. Yes. ಏನಂತ ಯಾವತ್ತು ಲಿಸ್ಟ್ ಆನ್ ಡೇಟ್ ಕೊಟ್ಟು 15/9 interim order is extended to the next year. I don't know. Whatever the interim order as modified, the order dated 28/7/2022 is extended. Then next date ante ಏನು ಇಲ್ವಲ್ಲ ಇಲ್ಲಿ. Next date ante ಏನಿಲ್ಲ. ಅದೇನು ಬರಬೇಕು. ಇವೆಲ್ಲ ವಕೀಲ್ ಸಂಘದವ್ರೆ ರಾಜು ಅದೇನು ಅಡ್ವೊಕೇಟ್ ಕರೆದು ಹೇಳ್ರಿ ಇದು ಏನ್ ಅದೆಲ್ಲ ಯಂಗ್ಸ್ಟರ್ಸ್ ಎಲ್ಲ ಈ ತರ ಏನ್ ಸಿಲ್ಲಿಯ ಬಿಹೇವ್ ಮಾಡೋದು ಹಿಂಗೆ ಹೇಳಿ ಅವ್ರಿಗೆ ಇಟ್ಸ್ ಸಮ್ ಸೆನ್ಸ್ ಇನ್ ಟು ದೆಮ್. ಯಾರೋ ವಕಾಲತ್ ವಾಪಸ್ ಕೇಳಿದ್ರೆ ಫಸ್ಟ್ ಬಿಸಾಕ್ಬೇಕಲ್ಲ ವಕಾಲತ್. And he is coming to the High Court and is justifying his action. ಅಲ್ಲಿ ಇಲ್ಲಿ ಬಂದು ಜಸ್ಟಿಫೈ ಬೇರೆ ಮಾಡ್ತಾರಲ್ಲ ಏನು ಸ್ವಲ್ಪ ಹೇಳಿ ಕರೆದು. ಸರ್ ಶ್ರೀ ಪ್ರಸಾದ್ ಏನಂತೆ ಅದೇನದು ಏನಾಗ್ಬೇಕು ಟಿ ಎನ್ ರಘುಪತಿ ಅದೇ ಫೈನಲ್ ಡಿಗ್ರಿ ಆಗಿಲ್ಲ ಅಂತ ಏನ್ ಮಾಡೋದು ತೋರ್ಸಿ ಹೆಂಗೆ ಅಂತ ಫೈನಲ್ ಡಿಗ್ರಿ ಡ್ರಾ ಆಗಿಲ್ಲ. ಫೈನಲ್ ಡಿಗ್ರಿ ಡ್ರಾ ಮುಂಚೆ FDP ವಾಸ್ ವಿತ್ಡ್ರಾನ್. ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ more in the subsequent FDP that is filed ಇದೇ ತರ ಇದು partition ಆಗ್ಬೋದು. Who knows? What you can do is you can tell the court to direct the commissioner. Equities ಅಲ್ಲ ಹಿಂದೆ ಮಾಡಿರೋ ಸ್ಕೆಚ್ ಇದೆಲ್ಲ ಅದೇ ತರ ಏನಾದ್ರು ಸ್ಕೆಚ್ ವರ್ಕೌಟ್ ಮಾಡಕ್ಕಾಗತ್ತೆ ಅಂತ ನೋಡಿ. Request of the counsel for petitioner list on. Mr. A.V. Gangadrappa, Manohar B.K. There is no representation for the petitioner and respondent. As a last chance list on date. Sanjay H. Setia. K.V. Monish Kumar. There is no representation for the petitioner. List on as a last chance list on 15 September. Dhruva Kumara. Yes, please. What is sir? Defendant number 4 is the impleaded respondent. Defendant. Defendant number 4 is the impleaded defendant. Subsequently, you are impleaded after the fourth plaintiff was Adanaki. But different evidence close ಆಗಿರ್ಲಿಲ್ವಲ್ಲ. Different evidence close ಆಗಿರ್ಲಿಲ್ವಲ್ಲ ಅಂದೆ.
I want to read number 4. I will not
But either dismiss ಆಗಿಲ್ಲ, WP dismiss ಆಗಿದೆಯಲ್ಲ. That you see for review in the resolution only. But then you have to seek for review of this order. If that is then we'll look at the order passed to the trial court rejecting that application. Note it, close. Page 36. Page 36 is bunny. The earlier order passed to the trial court rejecting.
By that time, these loans were available. They were not needed. Therefore, when I finally finished, I helped those loans. But those loans were not.
You seek for review ಕೇಳಿ. You better seek for review of this order. Without seeking for the. Appeal is not maintainable. It's not hit by restricted principles of restricted. Straight away is conceding. That is conceding, sir. He wants it. The review actually you seek for the review actually will keep this pending, but no stay. We make a review actually I'll stay the whole. The request of the council for petition list. Just after 10 days, according to just after 10 days. ಆಯ್ತು ಮುಂದೆ ಹೋಯ್ತು ಅದಾಗ್ಲಿ ಅದೆಲ್ಲ ಮುಂದೆ ಹೋಯ್ತು ಡಿಸ್ಮಿಸ್ ಏನಾಗಿಲ್ಲ 53 ಅಲ್ಲ ಎಂಟ್ರಿ ಮಾಡೋದು ಎಕ್ಸ್ಟೆಂಡೆಡ್ ದಿನ ಮಾಡಿ Yes. 60. No, somebody mentioned in the morning that this has become infectious. ಯಾರು ಹೇಳಿದ್ರಲ್ಲ ಯಾರು Has it become infectious or not? Agidya. So you are implemented in the final decree? Were you implemented in the final decree? ಇಲ್ಲಿ ಫೈಲ್ ಎಫ್ಡಿ ಫೈಲ್ next sir. Step paste. ಯಾವ ಫೈಲ್ ಇದು ಇನ್ನೊಂದು ಫೈಲ್ ಕೊಡ್ರಿ yes. Yes. Okay. ಅವ್ರ ಪ್ರಕಾರ ಇವರು ನಮ್ಮ ತಂದೆ ಸೊ ಇಸ್ ರಿಸೀವ್ಡ್ ಎಲ್ಲ ಶ್ರೀಮತಿ ಕಗ್ರಾಮ ಇದರಲ್ಲಿ ಅಲ್ಲ ಇವಾಗ ನೀವು ಯಾರು ಕೈಯಪ್ಪನ ಹೆಂಡತಿ ಜಯಮ್ಮನ ಕೈಯಪ್ಪನ ಹೆಂಡತಿ ಇನ್ಯಾರು ಪಾರ್ಟಿ ಮಾಡಿದ್ದಾರೆ ಇದರಲ್ಲಿ ಪ್ರತಿರಮ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಅದರಲ್ಲಿ ನೀವು ಚೆನ್ನ ಕದಿರಪ್ಪನ ಎರಡನೇ ಹೆಂಡತಿ ಮೊಮ್ಮಕ್ಕಳು. ಕದಿರಪ್ಪನ ಮೊಮ್ಮಕ್ಕಳು. ಶಿವಪ್ಪ ಪಾರ್ಟಿಷನ್ ಯಾರು ಮಾಡಿರೋದು? ಯಾರು ಮಾಡಿದ್ರು ಫಸ್ಟ್? ನಾರಾಯಣಪ್ಪ, ಸಂಜೀವಪ್ಪ. ನಾರಾಯಣಪ್ಪ ಸನ್ ಆಫ್ ಸಂಜೀವಪ್ಪ. ಇಲ್ಲಪ್ಪ. ಉಳ್ಳಪ್ಪ, ಚಿಕ್ಕಮುನಿಯಪ್ಪ, ಚಿಕ್ಕಮುನಿಯಪ್ಪ, ಕೃಷ್ಣಮ್ಮ, ದೊಡ್ಡಮುನಿಯಪ್ಪ, ದೊಡ್ಡ ಮುನಿಯಪ್ಪ ಎಲ್ಲಿದ್ದಾರಲ್ಲಿ? ಮುನಿಯಪ್ಪ ಸಂಜೀವ. ವೆಂಕಟಮ್ಮ, ಚಿಕ್ಕ ಕೈಯ, ಈಗ ಒಂದೇ ಹೆಂಡತಿ ಮಕ್ಳ ಮೇಲೆ ಹಾಕಿದ್ದಾರೆ. ಸಂಜೀವಪ್ಪನ್ ಮೊಮ್ಮಕ್ಕಳು, ಮೊಮ್ಮಕ್ಕಳು ಹಾಕಿರೋದು. ಕದಿರಪ್ಪನ ಆಯ್ತು. ಅಸ್ಯೂಮಿಂಗ್ ಇದಾಯ್ತು. ಇದು ನಿಜವಾದ್ರೆ ಜನ್ ಕದಿರಪ್ಪಂಗೆ ಅರ್ಧ ಭಾಗ ಹೋಗುತ್ತೆ, ಸಂಜೀವಪ್ಪಂಗೆ ಅರ್ಧ ಭಾಗ ಹೋಗುತ್ತೆ. ಯಾರಿಗೆ? Whether that issue was not considered in the RFA, that issue was not considered. Page number? ಅದೆಲ್ಲ ನಾನು ಕೇಳಿದ್ದು. ಈ ದೊಡ್ಡ ಚೆನ್ನ ಕದಿರಪ್ಪನ್ಗೆ ಗ್ರಾಂಟ್ ಆಗಿದ್ದು ಅಂತ ನೀವು ಹೇಳಿದ್ರು ಅಲ್ವಾ? So therefore now you are saying that this property could not have been partitioned because it is granted exclusively to ಚೆನ್ನ ಕದಿರಪ್ಪ. ಇವ್ರಿಗೆ ಯಾರಿಗೆ ಸಂಜೀವಪ್ಪನ ಮಕ್ಳಿಗೆ ಶೇರ್ ಇಲ್ಲ ಅಂತ ನೀವು ಹೇಳ್ತಿರೋದು. That contention was considered in the RFA is what I am asking you. ಆ contention RFA consider ಮಾಡಿದಾರ? ಹೆಂಗಾಗುತ್ತೆ? ಹೌದು ಸರ್. Sir, please come to para 27. Para 27 ಓದಿ.
now it was granted to the Karnataka. The eldest one of the applicant tried on the person actually that is 19. There was no partition of the and both of them
ಕನ್ಸಿಡರ್ ಮಾಡಿದಾರಲ್ಲ ಅಲ್ಲಿಗೆ ನಿಮ್ದು ಏನಿದೆ ಅರ್ಧ ಶೇರು ನೀವು ಫೈಟ್ ಮಾಡ್ಬೇಕಷ್ಟೇ. ಪಾರ್ಟಿ ಆದ್ರೂ ಕೂಡ ನಿಮ್ದು ಬರೀ ಅರ್ಧ ಶೇರ್ ಮಾತ್ರ. ಅರ್ಧ ಶೇರ್ ಅಲ್ಲಿ ಮೊದಲನೇ ಹೆಂಡತಿ ಕದಿರಮ್ಮನ್ ಮಕ್ಕಳು ಜೊತೆ ನೀವು ಫೈಟ್ ಮಾಡ್ಬೇಕು. ಸೊ therefore it is dividing the properties into two shares. ಎರಡು ಭಾಗ ಮಾಡ್ಬೇಕು. ಒಂದು ಭಾಗದಲ್ಲಿ ನೀವು ಫೈಟ್ ಮಾಡ್ಕೋಬೇಕು, ಇನ್ನೊಂದು ಭಾಗದಲ್ಲಿ ಅವ್ರು ತಗೊಂಡು ಹೋಗ್ತಾರೆ. ಸೊ ಒಂದು ಭಾಗದಲ್ಲಿ ನೀವು ಫೈಟ್ ಮಾಡ್ಕೊಳ್ಳಿ, ರೆಸ್ಟ್ರಿಕ್ಟ್ ಯುವರ್ ಕ್ಲೈಮ್ ಓನ್ಲಿ ಟು ದಟ್. ಅದಕ್ಕೆ ಗ್ರಾಂಟ್ ಮಾತ್ರ ಪಾರ್ಟಿಷನ್ ಕೊಟ್ಟಿರೋದು. only the extent of land which is covered by the order of grant ಅಷ್ಟಕ್ಕೆ ಮಾತ್ರ ಪಾರ್ಟಿಷನ್ ಕೊಟ್ಟಿರೋದು. You can't now turn the clock back. After the High Court has already passed an order that is the joint family estate ಇಬ್ರಿಗೂ ಅರ್ಧರ್ಧ ಭಾಗ ಬರುತ್ತೆ ಅಂತ ಹೇಳಾದ್ಮೇಲೆ how can you turn back the clock? Then better you file a suit of separate suit. ತಿರ್ಗಾ ನಿಮ್ಗೆ ಇಂಪ್ಲೀಟ್ ಮಾಡಿದ್ರೆ ತಿರ್ಗಾ ಫಸ್ಟ್ ಇಂದ ಶುರು ಆಗುತ್ತೆ ತಿರ್ಗಾ. ಯಾರು ಅದರ್ ಸೈಡ್ ಯಾರು? There is Mr. Anand, V. Anand. No representation for the response. ಇಲ್ಲಿ ಏನೋ ಬಂದಿದ್ರಲ್ಲ ಅಡ್ವೊಕೇಟ್ ಯಾರು? There is no representation for the respondent list on date 16 September. Intimar Ridya. Intimar Ridya. Intimar Ridya. ಬನ್ನಿ ಅವ್ರು 15th ಬನ್ನಿ ನೋಡೋಣ. The trial court is directed not to finalize the fine, not to draw the final decree until the disposal of this petition. And short accommodation. Request to the council of Impleading applications are filed here. The proceedings are on before the NCLT now entered. So what is there any proceeding pending before any company law tribunal? Yes. The Sumadura could be a project, but if it's against an entity, source is in. Source is in. What is challenge here?
India, that's the last thing. And there, also did not practice the matter.
You're a purchaser.
He filed an application and he. The motion to create this, based on that, the overall proceedings. And then.
So what is the date of option C?
Option says 14/11/2019.
14/11? No, but NCLT ಮುಂದೆ ಇತ್ತಲ್ಲ ಆಗ್ಲೇ. Okay. Yes, please. This is page number, annexure K. Yes. But should you not go before the NCLT? Yes.
These people were there, and the road that's where I think also considered a part of the way question they instrument to work and MS Ansari under the ID code respect of corporate data. The very limits of that they have put as in means suitable as the motivation. Whereas others will be deeper. This was the difference. It had different. Trying not to Para 21 years. Para 21 page 19. The corporate data, this paragraph is very important. Corporate data was a by India Limited, she the letter of all the last 5 lines in the same paragraph. There is another unit that the first party was unable to deliver will allow other unit in the same project or other projects. Therefore, the initiation of the CRP against the corporate data should be directly reference further. Not all the projects will be limited as initiated in this case. Now the motion are going to open page 96 months.
But how do you say, madam, all the funds are inextricably linked in various projects? How do you find out which money has gone where? No, correct, but how do you demonstrate that the money which is collected from that project alone is invested in that project? Hmm.
Also, there is a point of view that owned by us, or actually interested in taking right of that or because of advance to the data. However, instead they have strategic system in the case of flat fire from the and that then instantly passes an order, calculate the exchange.
Yes.
What the is the law issue. The other particular opinion that African experience and it because of the order that is other actions and find the instance application are not at all maintainable. Therefore, the use of responsibility, they have initiated the reference to the party, widely standard register, be interpreted and right in relation to the project things smuggled boldly and not in respect of all the projects of the corporate data, so that they have been initiated by the activity in the party. We concluded in terms of exact provisions of the board and the board say like that. They are also supported by it because the government of Ramadan is so, idea number so and so around this.
No, but please tell me whether this Sumadur Dreams Sumadur project is registered as a company in itself,
It's also registered
as a company. Is that E with this name? Dreams Sumadur project. Dreams, madam. Dreams Infratech. What is that? Correct. Therefore, how do you establish that the monies that are collected in some other property project is not pumped into Dreams Sumadur project, or whether the money is pumped into Dreams Sumadur is not invested in some other project? This is not a consumer forum case alive. If it was a consumer forum case, what you say is right. But this is under the IBC code. Yes. Project, adike kelidu, ಒಂದು project ಮೇಲೆ, so you would definitely not collect monies for a particular project. No, you would have showcased, no, you could have showcased all your projects. It's a different thing. You could have. No, we are not correct. Correct. You are only an auction purchase. I do understand. Problem is, by the time a proceeding was initiated before the NCLAT or the CLAT, whatever, it was only thereafter that proceedings are initiated to sell the property to your claim. Huh?
On that day, the corrected case was coming over, we have been lifted up. There was three kinds of application of and these were not able. He not been able to. And this is what we different project for different guarantee. But also,
Yes. Hold it. Please sit down, take your seat. You will have an opportunity. Wait for your turn. Correct. When was the CRP filed? When was the CIRP filed? 2019. Hmm. Hmm. Yes. Yes.
You to be perfect at working order is not challenged to them. The challenge in order after the exit that probably they will not have wider than this. This has not been challenged and the application conditions which
Where is the C? Do you have a copy of the CRP? Yeah.
we are not like parties also.
Correct. ನಿಮ್ಮ ಹತ್ರ ಇರಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ, but during the course of the proceedings, you must have got a copy. No, but unfortunately, the company which is sought to be liquidated is Dreams Infra India Limited. Dreams Infra India Limited is a company which is proceeded against in the CIRP.
Initiated by because he was one of the beneficiaries of the things for the parent. That's where I wrote this,
Correct.
So 84 initiated by the other way. He was
Correct. IA number 204 of 2020. IA number 204 of 2020 was in respect of Dreams Sumadura project. That I can accept. I think CP 84 it holding. So this IA is filed by these people, Yaro. This Ashok Kriplani in respect of this Sumadura project. Oh. So IA number 204 is in respect of that project. Thereafter, but I still fail to come to terms. Corporate debtor is the company.
That's one aspect. That's a different aspect. The matter of
I would say that it's better that you go before the NCLAT and get a clarification that this project or this. I could believe a Kripalani resolution professionally, okay, we'll say that he is not there. But the fact of the matter is there's some proceeding before the NCLAT which concerns a corporate debtor who is Dreams Infra India Limited. That is a corporate debtor. I think that is better. Yes. Let us see what is it you want. Please get it done. If they have gone before the NCLAT, then you have to wait. What is the number? Company appeal. Please give the number. Control is the learned counsel for the respondent number. Whom do you represent? The counsel for the respondent number 2 and 3. Counsel for the respondent number 2 and 3 submits that. So we do not know who you represent this Mr. Ashok Kripalani, who is the receipt. In the place of Mr. Ashok Kripalani. Where is that order? Substitution guy, even the application is substitution. If the resolution profession is changed, automatically he will be substituted. The counsel for the respondent number 2 and 3 submits that a resolution professional appointed by the NCLT has filed company appeal number. Company appeal 80. What is this INS? Insolvency 851/2020 before the NCLAT regarding which is this project? Regarding the projects which are propounded by Dreams Infra India Limited, and that the funds of the corporate debtor is enmeshed in various projects, and therefore there cannot be an order to a project in specific. Full stop. In view of the above, unless the NCLAT decides the above question, proceedings before the executing court cannot. Proceedings before the executing court in commercial OS number, in commercial execution number 3193 of 2017 cannot proceed. In that way of the matter, all proceedings in commercial execution number 3193 of 2017 on the file of the 89th Additional City Civil and Sessions Judge Bengaluru is stayed until disposal of the company appeal 80 in insolvency 851/2020 is decided by the it's decided, it's an obligation on the part of the court. Banda, please wait. NCLAT. Stop. It is, however, open for the petitioner. It is, however, open for the petitioner to seek modification of this order if the circumstances permit to do so. Yes. Huh? This is fishing in troubled waters.
I am for the petitioners in this case, my lords. I am for the petitioners in this case, my lords. Seal number 63.
My lord, one humble submission, my lord. Your mic has been muted, my lord. I request the court officer to.
Yes.
This is proposing to the fire. This is the issue to the respondent. The respondent, in their appearance, objected the second course. We have a witness. Okay, first course. Second course. Therefore, he
is entitled to do so. Yes.
Justifiable reasons, not being prompted by a land shark sitting behind her and propping her. Then it is not justifiable. Including, I would make a submission that the time to get to finance the land shark behind the form. See, all of these three testamentary documents the offices of Mr. A.N. Jayana, his offices were legal advisors. Like the estate husband was a barrister. He owned vast properties in therefore, he was very close to the A.N. Jayana. The services of the A.N. Jayana in the drafting of the will and the two forces. What will notice is that witnesses, the will and the two forces are associates of the elder, and in fact, the disputed codicil, the second codicil, as witnesses.
So what is the instant application now?
the second officer has suffered a heart attack. His heart is functioning less than 24%. The cardiologist has advised that cannot attend, be home or attend court. It's not supposed to might stand or even be home for me. Now, heart is in a critical condition. Though he's able to manage himself at home. When application was filed after the matter was converted into the suit, I don't know. I have to do research with the two.
Yes.
So we moved an application on the 26 1 and 2 of CPC. The appointment of a commission. And we supported the application along with a medical certificate of the cardiologist. The defendant responded from a law based frivolous objections, and the court on 2 grounds rejected my application. I called out to the relevant paragraph. The 2 grounds were to have another witness in the room who was a clerk from Siddhartha. Both of them are right. The one is difficult health. Frankly speaking, I am the master of the case. I would like to have a lawyer impose first, and then I would advise my client to do. And therefore, the court was requested to appoint a commission to examine the case. That was rejected on these grounds. One, that you have another witness. So you examine him first. One. And number 2, the cardiologist's medical certificate does not certify that he is legally sick. We were taken aback by this perverse order. Am I, by default, required to certify every cardiac patient? A leading cardiologist is certified. He has to mark. How could the presiding officer ask as per his mental witness? It was bizarre for him. Obviously, it was a perverse order. The other ground you took was that you could examine the other witnesses. And until and unless you could be many note numbers in the appeal order, until and unless medical certificate certifying the mental witness of the witness, which is wrong, is something cannot be. He was an insult to a counsel, he was an insult to any individual. There is nothing at all that remotely indicate personal opinion. The court have drawn an inference. This is not done. Then, we also suggest if you want to publish this court immediately by way of so the docket of this court is exploring what Article 27 petition. What we did was, Lord, we left the evidence of the second witness to complain. After all, it was not a complete dismissal. We only said to examine the other witness and then get a witness. It's a challenging about he decided to leave the evidence of the clerk. Though, kindly note, though we were not obligated in law to follow the what would have told me how I should read my evidence. Doesn't matter. His time was running out and we were only concerned about this. As I talk today, I run the risk of losing it.
Yeah.
So, he also stressed on order 18 to 16, which gives the power of the court. The power of the court to examine a witness on emergency situation. He said this is a crucial witness. Staff is only functioning 24%. And he records the evidence out of it. That was not needed. It doesn't matter. They examined the and then it was posted for the cross-examination. At that time, they filed a memo stating that we cannot cross-examine until and unless both our witnesses. I cross-examine this witness and causes prejudice to me because quite well taken. So you don't want me to examine the other witness on the one on that. The other right you will put in a memo stating that I will not cross-examine the clerk until and unless the other witness is examined. In one breath, you will say that. In the other breath, you will object the appointment of a commission. This is the log jam in which we have found ourselves. And the court also put us in a position like that. But compared to the first condition, examining the other words. And further examination could not go further because they didn't understand. I understand that, but I don't accept that they were object to the examination. We also produced a medical certificate against the trial of this. Satisfying the conditional order pass, the content unless you get a medical certificate and witness, you will not appoint that. So the trial is certified. The model is certified that auto-based form is mental faculty are absolutely fine. And only the unit medically advised. We produce that and file an application now. Those two conditions on which my application was rejected have all been complied with. Finally, proceed to appoint a commission. The application for appointing a commission was filed in November 2021. The request under order 18 to examine Mr. Madhuk's on the first possibility of brief now. Today, as we argue, we are approaching September. And very successfully, high level of advocacy. We are ashamed. I'm not able to get commission appointed. It speaks badly about me as a counsel. I'm not able to get a simple permission on the examine a witness despite complying all powers. It speaks badly about my advocacy. Nevertheless, the application for appointment of a again was moved under the inherent powers of the court of 151. And then there was an argument that court has become countless of issue, cannot revisit this law. But we also have an abundant portion filed. The application also, if necessary, very under the review policy. So, in my opinion, it does not apply. If the conditional order satisfies two conditions, one on the bottom. We file that application. It is again unreasonably vehemently objected, and the objection is accepted, and the application is again rejected on the preposterous ground that the court has become functus officio.
Yes.
The court also formed an opinion that the IRS has not examined the Military Commission of India. So we were constrained to approach this court under Article 227. The desired circumstances under which the court has prevented us from examining the cases.
Yes, sir.
So that
So you are acceptable for a commission with a doctor.
so that you are not blame.
Yes. No, why can't we have a cross-examination or video conference? Let the court also have a, what do you call, let the court also know the conduct of the witness, the state of the mind of the witness, the state of health of the witness. Let there be a video, we see. Let the cross-examination be done under the watchful eyes of the court through VC. It's all right, you said it, you need not say it again. Once you have said it, you need not emphasize it. You need not underscore it again and again, Mr.
I will explain that. I can't leave this unanswered. Let me explain to the learned senior advocate why you were misled. Let me, you should understand why you were misled. Let me, be respect. Respect. You will have to apologize to me. Be respect.
Yes, Manian. Mr. Manian. Don't get into, no, don't ruffle settled feathers, Mr. Please don't ruffle settled feathers. Why you want to unnecessarily? No, the things are come to a, we have reached a common ground. It's in the interest of the parties. Yes, that is it. See, the whole purpose is to get the evidence of the witness, full stop. Why are you taking? No, ultimately, it is who. Ultimately, I decide what conditions should be imposed. You need not. Yes. Don't, Mr. Don't get it. Don't get into a verbal duel with your opponent. This is not in good taste. No, don't, Mr. Don't get into a verbal duel. Correct.
But I have here we have is muddy.
Then you should have become a judge. You should have become a judge then.
Unfortunately, I don't have the arts of.
If you think.
I don't need to argue. I don't know the other part of.
Therefore, if somebody is judging, please don't. If somebody is judging. Please don't get into fisticuffs or verbal duel with the. Yes.
Necessary, but let my friend also understand that I haven't wasted no unnecessary. I don't want to ruffle any further. If you hear me out, then you will know.
No, it's all right. Now that we have reached. Yes. So third reason.
No, you will have to hear me and you will have to apologize to me and to the court.
Sir.
You don't have that.
Mr. Manian.
What kind of language is using for the greater security? Where a dam go to hell? What kind of language? What kind of thing advocates have you developed in this bar? What is race in the word carrot dam? All of the content. You like carrot dam? What kind of language, sir? Carrot dam? Go to hell? Can you record that?
Sir,
That is what I deserve. Beautiful.
please restrict your, Mr. Please restrict yourself to the case. If it is going beyond, no, I will, Mr. I will rein in both the parties. If you take, yes, I will rein both the parties. I will rein in both the parties. This is, no, Mr. Manian, no.
I cannot dam, go to hell.
This is, if you say something, something will follow. So better you keep the temp.
Sir, with due respect, I cannot dam, go to hell.
Don't generate, Mr. Don't generate heat in the court.
I am not generating.
Please don't.
I can't take a sliding down.
Please don't generate heat in the court. Please keep your voice down. Please keep your voice down. Please keep your voice down. No, it's not suo motu action. Mr. If you say something is going to come back. Yes. Yes. I will decide. Do you have anything else to say? Is there anything else to say? I'll list it tomorrow for dictation. Is there anything else to say? Mr. Manian. Please, no. I've seen you. But I have not seen this part of you. All these years. I don't know. I have not seen him. I have not seen him, but today it is actually.
How old are you, sir?
Mr.
Your age? Go to hell, your counsel was maybe 20 years younger to you. What is this? You're my father's age. And you tell me to go to hell and damn you? Yes, you're my father's age, I respect you.
Mr. Manian.
Yes, I'm sorry, my lord. I can't be bumped down. Every time I get hammered.
No, it's not. You will get hammered if you continue to. No, Mr. I'm trying to rein in both of you. I'm warning you again. No, please, enough is enough. We have reached a common ground. You wanted a commissioner to be appointed. He has conceded. No, please wait. I don't want it. I don't want to indulge in further conversation. He has accepted to a fact. Whatever that you suggested, all that he wanted was a doctor. That's the end of it. There's no need for further confrontation at all. Where was the need for you to? Not necessary. For what? For what purpose? For what purpose? Now, whatever you wanted is accepted by the other side. So where's the question of full consternation again, Mr. Manian? Huh? He did not make such a submission. He said that they did not cross-examine that witness because they wanted to cross-examine both of them at a time. Number one. Number two, he said that he does not have any objection for an appointment of a commissioner, provided a doctor is also present, so that any untoward incident can be avoided. That this is all he said. And you wanted to prove a point, something that, I mean, of course, which I do not know. You wanted to prove something.
I want to anything.
And you wanted him that you expected that he would apologize to you. What is this?
Yes, he should, because I will extend the court.
Has he appeared before? Mr. Has he appeared in the trial court? Has he appeared? Correct. Has he appeared? No, has he appeared before the trial court? Yes. Has a senior counsel appeared before the trial court?
Is that an excuse to be?
No, I'm not saying it's an excuse. Has he appeared?
He was not appeared.
Then why do you accuse him? Why do you expect an apology from him?
Because he misled the court. Can I expose him?
Did he appear before the civil court? Did he appear?
That is the excuse the counsel can say, I'm sorry, I misled the court, I did not appear at the trial court.
You can expect an apology from the counsel who misled, not Mr. Rao, who was the senior counsel. He's obviously.
As a senior counsel, he is responsible. He can't leave the ship. I leave it. And that entails an apology from him, saying that I'm sorry, my meeting counsel misled me.
Yes.
Or is it for the senior counsel to say, I am not responsible, the meeting counsel misled me, so therefore go to hell, damn you. I want you. I can't. Yeah, it was so.
I will list it tomorrow for dictating orders. It's not the power of the authority. I'm only. No, it's not silencing, Mr. Manian. No, Mr. Manian, it's not silencing. Yes.
We are not doing this. Even my people also misleading on some occasion. I would readily, as soon as my friend would point out that I'm wrong, I would readily cross-check the witness. And I would be the first and forthright apologize to my friend and to the court. I am a human being. But I would never say, go to hell, damn you.
Mr. That is, if you say, see this, it's like an echo. See, it's like an echo. If you say something against the wall is bound to throw something back.
Court has the power to locate the law. I'm sure my Lord is wrong by it. Lord will not deny the fact that he said, go to hell and damn you.
Yes.
Lord heard it, court heard it. I will see to it, goes to the logical end. The senior counsel cannot do this. It's a very bad account. It's like that. On the merits of the matter, the Lord, DC's petition and petition. Very right. It is not open to defense act. It takes term of who should be present, who should not be present. If the examination of my witness, both particularly when a cardiologist is certified, it will be one. This is an article 227 proceeding, the Lord spoke on testing the veracity of the order passed, or pass orders, setting aside the orders, the Lord finds it fit. Regarding the VC, the Lord may take it, but I have consented to it. On the suggestion of the court, it came from the court, I find that a very valid suggestion. The Lord, after 227 proceeding, may take it that the councils have agreed, including the petitioner's councils have agreed. I tried across the bar and submission. The VC is perfectly acceptable to us. Regarding the further conditions ought to be imposed, sorry, my Lord, we do not accept unilateral conditions for no reason whatsoever. It is not supposed to have reason forthcoming. It cannot be.
Mr. You said he's got only 24% heart functioning. What if suppose the cardiologist is certified and you are basing your claim on that cardiologist certificate? What if tomorrow, during the course of cross-examination, he has maybe palpitations, he is not able to withstand the cross-examination? Somebody should be there to stand by next to him, to assist him. Tomorrow if something happens, to him in the course of cross-examination.
I'm sorry, are you all sitting in judgment over a cardiologist?
I'm not saying you are sitting.
Cardiologist has said clearly.
Mr. Manian.
You are sitting in judgment.
I'm not sitting. No, I'm not sitting. Mr. Manian. I'm not sitting over judgment or anybody's opinion. Please, would you hear me out? Would you hear me out first? If I also raise my voice, this court will become a, what do you call, cacophony, that's it.
Yes.
Please don't raise your voice. No, please don't raise your voice. Please don't raise your voice, Mr. Manian. If you are willing to speak in a low tone, I am willing to listen to you. But if you raise your voice, I'll also have to raise my voice. Let us conduct the court proceedings in a very harmonious way. Yes.
Yeah, let us submit to the court. My Lord, The certificate from the cardiologist is very clear.
Mister, I accept that.
Then why is that need to even?
Shouldn't a doctor be there?
Why is the question? I want to go ahead.
No, why shouldn't the doctor be there?
Should not.
Why shouldn't the doctor be there is what I am asking you. Because his condition is so critical, so sensitive. If something happens to him in the course of cross-examination.
I can go only by, even if you respect what mistake me, the enormous knowledge of law which my law has, I do respect. I only appreciate a legal point from law can say. But when a cardiologist from a law's opinion, which is better for the patient, due respect, I would not go by my law's opinion on medical science. I would go by the cardiologist.
I would not ask you to do that. No, what is running in your mind? What is running in your mind? You please tell us. Put it in plain words. Put it in small, simple words. What is running in your mind?
My mind. This is running in my mind. The other side got it.
No, please forget the other side. Forget the other side. What is your opinion of having a doctor at the time of cross-examination? Yes or no? You want a doctor to be next to the witness?
But I'm sorry, this is only because my lord asked me the question.
No.
This is not legal.
Mister, give me an answer.
And as a trained lawyer, I'm accepting it because my lord thinks it. I believe it. And I would, and this is again, if my lord goes it.
I asked you. No, please listen to me. I asked you a small question. Please put it in plain, simple English. What is running in your mind about the presence of a doctor, whether he is required, not required?
I read some other case only.
No, please tell whether it is required first, then you explain. First, you please tell us whether it is required, not required. Then you explain it.
I had some other case only. Very happy to see me after many years. I thought the meeting personally to see him. I know myself. I found him very joyous. He was so happy to see me after 20 years. He inquired about all our members in the bar, and he asked about how practice is going on, about my possible judgeship if my lord insists upon. I said, I'm sorry, I'm not in the race anymore. All the discussion we had, and with due respect, my work. Therefore, I find this presence of a counsel demeaning, slowing the heart to it. It's not that I go a heart, a doctor is always sitting next to his side. I know the applicant is another one. He's still alive, he's doing well. It's not that a doctor asks him to do.
No. This situation,
Answer the question.
This situation, he will be on a roller coaster ride for at least half an hour or 1 hour when he is put in the cross-examination. It will be a roller coaster ride for him. Obviously. Yes, obviously.
I will not say that. I want to see that the entire education finance for a developer's mind. That is why customers starting to avoid a condition. Request for appointment of the doctor. Something if the Lord is making a statement, I find the legally acceptable. But actually, the Lord is asking a question. What is your opinion about it? The answer is only this. About legally, you respect the Lord, legally, I find that is only on the basis of an unsubstantiated basis and misreading the cardiologist is opinion. Cardiologist has clearly said that we are position to go. So ask me, other than a lawyer's question, is there anything wrong?
Can a cardiologist know? No, can a cardiologist know what will be the questions put to a witness? Will a cardiologist know what will be a question put to a witness? Not necessary. Not necessary. No, not necessary, mister. No, I'm not arguing against you.
See, then in what cases cardiologists have to law to decide. See, medical advice is what I all have to go. Don't have to go by medical advice. And you see the problem of one thing.
Yes.
The explanation for 26 1. And why is it coming from a person, the person knows? I am the person who is feeling it. I am making an application, it is not for me. I have to control about my business.
Yes.
How is it coming from the other side? And he is an independent witness. He is not on the other any pressure to testify in my favor. Okay. So I am a beneficiary. How is that? How does it matter? Not any pressure. Not party to the case. Third party. What is the kind of pressure is what I have in mind? I can understand. I can understand it is a problem of dispute.
Mister, I am only concerned about the witness. The witness, once he is examined before the court, is in the custody of the court. Please take that into account. So I have to ensure the safety of that witness. Safety and well-being. Obviously, Mr. His heart is 24%. Mr. Manian, I think you are going out of bounds. You're going out of bounds. Yes. You're going out of bounds. Yes, you are. You are. If you want, I can put it on record. I can put it on record if you want. Pardon? Yes. Yes, you have anything else to say? Yes. Who is this doctor? Who is this doctor who has certified his health condition? Where's the report of the doctor? We will please get a consent from this doctor, whether he is willing to be a part of this.
I will get it. Okay.
Whoever. Yes. Yes, get his consent. Get the consent of Dr. Srinivas.
For average 2 days time, so that we will ensure the doctor is present at the request of the responding company. Yeah,
The request of the counsel for the petitioner this day after tomorrow. The petitioner is directed to secure the consent of Dr. V.K. Srinivas. Dr. Srinivas.
Our writing with the sectors.
No, just now you said you will secure. That's why. The counsel for the petitioner is directed to explore the possibility of obtaining a consent of Dr. Srinivas V.K. to be present at the time of cross-examination of Mr. Madhu K. Swami at his residence. And if yes, the dates which will be convenient for him, and the convenient dates, Yes, list there for tomorrow.
What about costs?
Yes, both of you will have to pay cost to the High Court for tormenting me.
Yeah.
No, for tormenting me, both of you will have to pay cost to the High Court.
Answer for that.
No, I would suggest to you, Mr. Manian. No, I would suggest to you, no. generally, I mean,
If the submission
no,
was
I'll
made in
no,
November.
I'll tell you.
The submission was made in November.
Yes.
They bargained because he might die. Isn't it? So, when the trial court. Yeah. Finally, only. I have it down.
Anyway, no, this doesn't augur well for the system. This does not augur well for the system.
Somebody has to build a cat.
Not this way.
It has to be
Not
done.
this way,
I
not
don't
this
have to see to it.
No, not this way.
November, the submission can be made in November. Before the
That is right.
How do you justify
Yes, that is right. That is right. What you have a point in that.
My lord will also take note of the fact that the matter in which the trial court will report to the matter is a matter of serious concern. At the highest court, my lord, have to interest that. This is the way the application is disposed of.
Yes.
My lord will take serious note of it. Whether he has strong message to the lower judiciary that this is not the way it's done. I'm sure my lord has the power and my lord will do it.
Why don't you pen a few words?
You, my lord, as a
No,
counselor,
please pen a.
my lord, sees the seriousness of the injustice done. My lord, my client is not as strong as he was in November. The last patient, my lord said 24%.
You say the witness is your client.
Said 24%.
No, witness is your client.
And he said,
No, please tell witness is your client. Is the witness your client? Just now you said my client is a heart patient. Just now you said your client is a heart patient. Is the witness your client? So therefore,
no, let me tell you this.
no, this is what you said.
No, this all this hourly language of better be a doctor present if you come from November. Came only in September, August. How do you justify that? If this is the submission, then they took us for a lawyer, right, from November, wasting time of counsel and the court, wasting time of the lower court. If they are not contested unnecessarily then. The counsel sees the reasonableness of the matter and is there a submission knowing that it's not right. But when? November, December, Jan, February, March, April, May, June, July, August, over running around. As the judiciary not let us down by those perverse orders of a simple application for appointing a commissioner.
Maybe it also speaks about you, the way you have done it. Maybe because of
Yes, it speaks about me.
Yeah.
Yes,
It does.
counsel stands out.
Does. No, it does, Mr. It does. It does. You should also take into account the interest of your client when you are representing. When you are a client's mouthpiece, you need to be you should introspect and you should be very careful. You should be very careful about the words that you use.
I have no qualms about what I said. I make the assumption and reiterate it. It is a great service to justice of my lord. He takes note of the orders passed by this court.
That I will do.
My lord has the power.
So you have to.
And my lord will also draw adverse influence on the other side. Having delayed this matter from November and for a learned senior counsel today, very good step in the commission, accepting the appointment of a commission. But it doesn't take this long for the commission to be appointed when the witness, I'm sorry about my client, the witness is the heart patient. This 24% didn't look large for November, it looked large today. And the requirement of a doctor becomes important today.
No, I would say, no, this application. Yes. What, please explain that.
Case speaks for itself.
Yes. In what context are you quoting that?
The record speaks for itself. My lord, don't take it between you and me.
No, it's not taking between you and
I only
me.
represent a client.
Therefore, when you're representing a client, mister, you need not raise your voice. I don't know why you want to raise your voice. Why should you raise your voice? Then you please keep it
No,
down.
I can't. It's my nature.
Then you should keep it down. Learn it. Please learn it. If I can raise my voice, I can also lower it. Mister, please keep it down. No, please keep it down, mister. Please keep. Yes, that is better.
I found those judges more concentrating on the point of law.
Yes.
Are getting frustrated by the voice.
Yes.
I have heard of a few judges for various ironic. I tried my best, but my voice is high.
Please keep it there. Please keep it low. Please keep it low. Please learn it. Learn it. Please train it.
My voice, my Lord will
No, I will not. See, these things, Mr. Manian, these things will not perturb any of you. Mr. Any of your conduct, any amount of what you call raising your voice, it will not affect me. It will not affect me. Like I will decide the case based on the merits. That's it. Full stop. Whether you like it or not, I will decide the case based on merits. But I am telling you, you are risking your clients by indulging in this kind of attitude in the court. I am warning you.
Yes, warning. I will never appear my Lord. I will never appear any further trial because of my voice.
Please. Yes, Mr. V. Ramesh. Yes, Mr. Sampath Anand Shetty. Yes. Yeah, what is the suit for?
Partition.
It is for partition. Yeah, what is the application? Yes, Mr. Sampath Anand Shetty.
Yes, my lord. This is actually in paragraph 10. I'm sorry. Switched off. Your lordship, I have it day after tomorrow.
That request of the counsel for respondent, please day after tomorrow.
Court of sir. Court of sir. Sir, ಇದು serial number 62 ಏನಾಯ್ತು sir ಇದು? Hello.
Court officer sir. Serial number 63 ಏನಾಯ್ತು sir? 19th. Okay sir, thank you.
Sir, 62 ಏನಾಯ್ತು sir? ಅದು ಕೇಳಿಲ್ಲ sir. Sir, court of sir, the 62 serial number. Sir, 62. Sir, 62, sorry.
62, 16 September.
Okay, sorry. Thank you.
16 September.